Okay. All right, so I'm good to go, right? Okay. Good afternoon. This open meeting of the Board of Appeals is being conducted remotely while hybrid pursuant to Chapter 2 of the Acts of 2023. Ensuring public access does not ensure public participation unless such participation is required by law. This meeting will feature public comment. For this meeting, the Board of Appeals is convening in person and by video conference using Zoom app as posted on the town's website identifying how the public may join. Please note that some attendees are participating by video conference. If you're participating by video conference, be aware that other people may be able to see you and your computer screen, so take care not to screen share. All supporting materials that have been provided members of this body are available on the town's website unless otherwise noted. The public is encouraged to follow along using the posted agenda unless the chair notes otherwise. And so if you are participating by Zoom and you have a question, please use the raise hand button when we get to that point. And we'll do our best to get everyone in the order that they've raised their hands. Okay, so I'm going to call to order the September 5th special meeting of the Zoning Board of Appeals. We have the room 1 until 4 p.m. We have a big agenda, so I'd like to be as efficient as possible. Confirming members present, John Brescher on Zoom.
Here.
Elisa Allen.
Here.
Joe Marklinger.
Here.
Lisa Botticelli. Mark Poor. Jim is not here yet. Or not on Zoom? Okay, so we'll make a note later if he comes. Okay, all right. Okay. Would someone make a motion to approve the agenda as drafted? Okay, so Lisa made the motion and Elisa seconded. I'll do a roll call. John Brescher?
Aye.
Elisa Allen?
Aye.
Joe Marklinger?
Aye.
Lisa Botticelli?
Aye.
And myself, aye. Okay. At this point, we have the public comment section of the agenda. This is for items not listed on the agenda or reasonably anticipated to be discussed today. For public comment today, I think I'm within my rights, but someone correct me if I'm wrong about this, that to limit this to 15 minutes of time with a 2-minute time limit for each person who had a public comment. And if it's anything to do with either Surfside Crossing or the short-term rental remands, please hold that until the short-term rental remands the public hearing is closed. So we're not taking public comment on that. And Surfside Crossing will have a public comment section in that application. So does anyone on Zoom have a hand up for public comment, Billy?
I'm not seeing any hands online.
Okay. Ms. Perry, you have a public comment?
I think can everybody hear me okay? Okay, thank you. I think this board might be aware, just based on the local media, that I did file a complaint with ethics regarding a conflict of interest with members on this board. And I'm just wondering if members of this board who I filed the complaint against will be recusing themselves from the meeting with regards to that.
Public comment is not a section where we respond. It's just for you to make comments. So if that is something that comes up within the remand hearing, you could bring that up at that time.
Would you like to take a look at the complaint?
I haven't seen it.
Would you like to take a look at the complaint?
Can we wait till we open that?
I'm sorry?
Let's wait till we talk about Surfside Crossing.
Okay.
Okay. Does anyone
Thank you.
else have public comment? Yes, sir. Just if you can just say your name for the record.
Brooke Gibbs.
Okay.
I don't understand how you can draw conclusions as we only have 2 minutes to comment, a 15-minute window. I mean, this is a big deal to a lot of people.
Well, sorry, to clarify, this section of the meeting is only for public comment that is for items outside of what we're going to discuss.
Okay.
So once we open Surfside Crossing.
Right.
Then there'll be a section in that within.
I understand that.
Okay.
But this is not just this week. I'm watching the videos. I'm watching the whole process and how you guys railroad through all these procedures. And it's like, you don't listen to anybody. It's like close to public comment on everything. I mean, you don't let us get into like the back and forth as to how all these things are getting decided. You don't get into all the members of the board and conflicts of interest and all that. You just want to just like, oh yeah, it's just going to be okay. And I mean, everybody on the board is obviously conflicted. You should have somebody who's not conflicted make the decisions. And I know for a fact that everybody on the board is conflicted, personally. So how you can tell me I have 2 minutes to freedom of speech and public, whatever, am I on the clock? It's like, when are we going to have an open discussion that lasts more than your hour procedure? You're never going to get this fixed if you don't listen to everybody and what they have to say. Really, you're not. I have a master's in economics. I could tell you what the solution to both of these problems is, but you guys don't even want to hear it because you're too involved with too many fingers and too many pies to take your hands out of it and be impartial. Really, it's the truth. It really is. There's so many, everyone on this island knows everyone on this island. No local is going to not, go out there and just backstab their neighbor, okay?
Okay, I appreciate your comments.
Yeah, I know, but why are you, so explain to everybody here why you limit it to 2 minutes. And under what law and what reasoning and what public procedure and process you've got that you enable us to only have 2 minutes of opinion on your whole process.
I'm going to thank you for your comments.
I know you are.
As I said, we have a very packed agenda. This public comment is only for items we're not going to discuss.
I'm not discussing anything in particular. I'm asking why your procedure is so, what is it? What's the
The public
word?
comment section, from my understanding, and again, correct me if I'm wrong.
Yep.
Town council that's on.
Yep.
This is not for question and answer. It's only for a public comment about something that's not being discussed today.
Okay,
I'm
your
not-
15 minutes of public discourse or public comment, 2 minutes a person, is bullshit.
Thank you for your
Okay?
comments.
Yeah, great.
Okay. Is there anyone else who would like to make a comment about something that we are not talking about today? Okay. So we have no minutes to approve at this meeting. We're going to move on to new business. The first item under new business is the 2524 Surfside Crossing LLC, dealing with the Surfside Crossing 40B. Attorney Paul Haverty, I believe, is in the audience and will make the presentation for Surfside Crossing LLC. And once Mr. Haverty has completed his presentation, I would then ask George Pucci from KP Law, who's the town of Nantucket, serves as town counsel, and our 40B advisor to then present and explain to the board the scope and the audience, the scope of review on this land court remand directive and the action items as he sees it for us moving forward. So, sorry, did you want to go first, Mr. Feely?
Susan?
Some opening remarks, if that's okay.
So just identify yourself for the
Susan?
video, and I'll let you have the floor.
Sure, Jamie Feely, developer. Madam Chair and board members, thank you for the opportunity to address you and the public here today as we begin this remand phase of the process. I recall standing in this very spot at the introduction of the initial application in the first meeting with the ZBA on this project some years back. The first question that was asked, why condos? It seems this question is again central, as we are here to present some of the changes we implemented during the appeals process, shifting us to an all condos version of the plan. The answer hasn't changed. When I decided over 7 years ago to enter the affordable housing arena as a developer, and specifically to pursue a significant 40B project, now known as Surfside Crossing, it came with one condition: that any such project would be conceived and designed to serve the year-round affordable and attainable housing needs far beyond the minimum 25%. That commitment ultimately informed the all-condo approach by allowing us to maximize the amount of units that would be within reach of the year-round market, a market that's critically underserved here in our community. We've said many times throughout the process, we would love to collaborate with the other housing stakeholders in our community outside the ZBA process to achieve a goal of 75% year-round deed-restricted ownership in Surfside Crossing, inverting the minimum threshold and maximizing the public benefit. Some have asked, why not then aim for 100% year-round ownership? This question has been seriously considered by us and many we have been collaborating with. And in the end, the idea of creating a fully inclusive, I want to repeat that, creating a fully inclusive neighborhood that will represent and serve Nantucket's beautiful diversity is what trumped. Our community includes such an incredible array of socioeconomic representation, and we depend on every aspect of that diversity. There's no other neighborhood on the island that includes a significant representation of 80% AMI up to the ultra-affluent seasonal resident and everybody in between. Our goal is to have 25% of the units at the 80% AMI level per Chapter B or 40B regs, to maintain 25% of the units as unrestricted and available to all buyers at a market rate level, and for the middle 50% to create opportunity for all year-round buyers in between. These will be market rate units that require collaboration with others outside of this process to partner with in this effort. Although we cannot do this alone, we are committed to creating that opportunity and to forging a way to achieve that 75% goal. To those we have been working with already toward this end, we're grateful for your engagement and shared visions. We're very proud of the opportunity that this project is going to afford this community and hopefully at least 117 year-round individuals and families. We all know the need is tremendous. If we as a community have any hope of retaining those so vital to our daily existence, we need to offer viable homeownership opportunities. We all know firemen, police officers, teachers, coaches, steamship workers, restaurateurs, and retailers who have come for Nantucket's beauty and charm, but when the hard realities around housing set in, have to pack it up for more affordable communities. We have a revolving door for our young professionals and entrepreneurs that is not sustainable. This project is a solution, not the solution, but part of the solution. It is proposed with a very high quality approach to design and construction. It includes many community spaces designed and programmed to be inclusive for all ages, genders, to be family oriented, to be safe and supportive. This project represents an incredible opportunity for us to embrace the needs of today's Nantucket community. We acknowledge that today's community is very different from the community 30 years ago. Today's Nantucket community is far larger, with the school's largest school enrollment ever this year. It's far more diverse, from my perspective, in a beautiful way, and it's a lot more complicated. We need to continue to adapt and to meet these needs, the needs of our fellow community members. We are proud to be here in front of you all presenting what we believe to be an extremely thoughtful housing neighborhood designed to focus on and target the local needs. We're hopeful that you choose to support the larger goals of this project through the changes that we are now in front of you with. With that, I'll hand the presentation over to our attorney, Paul Haverty, and thank you for your time.
Good afternoon, Madam Chair, members of the board. For the record, my name is Paul Haverty. I'm an attorney with Blattman, Bobrowski, Haverty, and Silverstein out of Concord, Massachusetts, here on behalf of Surfside Crossing, LLC. You just heard from Jamie Feely, who is one of the partners of Surfside Crossing. His other partner, Josh Posner, is also here in the audience. Also with me, physically present today, is Don Bracken of Bracken Engineering, and we also have the project architect, Andrew Cochin, who is available on the Zoom. So as a quick recap, this matter is back before the Zoning Board of Appeals after a remand from the Housing Appeals Committee resulting from a decision of the Nantucket Superior Court overturning an earlier determination of the committee that the notice of project change filed by Surfside Crossing constituted an insubstantial change. As some of the board may recall, the project as originally proposed called for 156 units consisting of 96 condominium units in 6 structures, 16-unit structures, and also 60 single-family houses on small individual lots. The board ultimately approved a project consisting of 40 single-family lots and 20 condominium units. Surfside Crossing appealed that decision to the Housing Appeals Committee. As part of that process, Surfside Crossing was required to go through what is known as MEPA. That's the Massachusetts Environmental Policy Act. MEPA requires an applicant to provide alternative designs that reduce impacts. One of the alternative designs that was prepared as part of that process was a 156-unit all-condominium design. And as we went through the MEPA process, my clients determined that that 156-unit development was a superior design than the one that was originally filed with the board, and therefore it determined that it was going to make that the preferred design in the MEPA process, which then required it to go to the Housing Appeals Committee and submit a notice of project change to change the development from what was originally submitted to this new design. So that did happen. The Housing Appeals Committee ultimately issued a decision that determined that that change was insubstantial, which was then ultimately overturned by the Nantucket Superior Court. Because the alternative plan resulted in many significant reductions in impacts, that notice of project change was filed. So the benefits of this modification include a reduction in pervious/semi-pervious area from 284,452 square feet to 282,241 square feet. So a minor positive improvement. Total vegetated area on the site also increased from 306,155 square feet to 308,366 square feet. Again, a minor positive change. The bigger changes impacted include the total number of bedrooms. In switching to the all condominium design, the total number of bedrooms was decreased from 389 bedrooms on the original project to 283 bedrooms in the modified project. And there were resulting improvements as a result of that change, which include the reduction in the number of bedrooms reduced the sewer flows from 43,790 gallons per day to 31,330 gallons per day. So that's a significant positive improvement. The change to all condominiums and the reduction in the number of bedrooms also results in a reduction in vehicle trips. So the morning peak hour trips are reduced from 88 trips to 72 trips. The evening peak is reduced from 113 trips to 87 trips. And the total daily trips are reduced from 1,272 to 1,142. Finally, with the reduction in number of vehicle trips, the modified project also increases the number of parking spaces on the property. The original project had 266 spaces, and the modified project has 291 spaces, of which 281 will be constructed during initial construction, and 10 of those spaces are land banked to be constructed only if needed. And that came as a result of the MEPA process. When we were going through MEPA, they pushed back. They wanted additional undisturbed area if possible. So we agreed as part of that process to land bank a certain number of parking spaces and only construct them if it ultimately was deemed necessary. So the evidence is very clear that the change to all condominium units had a significant net positive impact on the project. And we continue to believe that the decision of the Housing Appeals Committee determining that this change was insubstantial was a correct decision. However, the Superior Court disagreed and overturned that determination, remanded the matter back to the board with an order that ultimately it be remanded back to back to the committee with an order that ultimately be remanded back to this board. So there was a certain process that occurred as part of that, and ultimately the Housing Appeals Committee issued a remand order, which includes a limitation on the issues to be reviewed. So that remand order limits this hearing to building types, including both architectural style and tenure, number, location, and size of buildings, increase in building heights, number and location of parking spaces, roadways and traffic circulation within the site and off-site traffic impacts if there is evidence that the proposed modifications increase those off-site impacts. And I've already stated, our traffic consultant submitted testimony during the process in front of the Housing Appeals Committee. That is part of our submittal for today's hearing that shows that the number of vehicle trips is decreased by the modification. Finally, open space design within the site and other matters within the scope of the remand, that is, matters affected by the proposed modifications that are currently unanticipated. So it's important to note that pursuant to 760 CMR 56.05 subsection 11 subsection C, that only the changes in the project or aspects of the project affected thereby shall be at issue in such hearing. I'm aware that Attorney Durensis submitted something to the committee, something to the board, arguing that the committee acted improperly in issuing its remand order, but Mr. Durensis only pointed to the provisions of 760 CMR 56.07 subsection 4, which addresses solely modifications during the process at the Housing Appeals Committee. It doesn't address the process in front of the board. That's governed by 760 CMR 56.05 subsection 11. And that is the basis under which the Housing Appeals Committee issued its remand order, limiting the scope of the issues to be reviewed and limiting the time for the board's hearing to occur. It's our position that the board's role in this remand should be limited to exactly what it would have been if the committee had remanded it to the board in the first instance, which is ultimately an up or down vote on the modification. As the board is aware, my client has commenced construction at risk and has put in place at great expense infrastructure to serve the 156-unit project. Accordingly, there's very limited ability at this point to entertain revisions to the project design. It's important to note that the committee has already ruled on a number of issues regarding local concern and determined that the regional need for affordable housing outweighs those issues of local concern. And again, none of those rulings were disturbed by the Superior Court. The only issue the Superior Court addressed in its decision was the issue of whether the project change was substantial or insubstantial. Now, this is relevant because pursuant to 760 CMR 56.05 subsection 8, subsection D, subsection 2, the board may not reduce the number of units for reasons other than evidence of local concerns within the power of the board. So again, we don't believe that there are any local concerns that would be appropriate as a basis for reducing the number of units that is currently before this board, because the Housing Appeals Committee has already ruled on those issues. It's my client's sincere hope that the board will recognize the extreme need for affordable housing and year-round housing in Nantucket and approve the 156-unit condominium development that has already been approved by the Housing Appeals Committee, but has been remanded back to this board for these further proceedings. I understand that the chair would like to go to Attorney Pucci after my comments are done. I would just note that once Attorney Pucci is finished, we have Andrew Kochin, the project architect, who will be ready to go over the changes to the design. Thank you.
Okay, thank you. Sure. Attorney Durensis, asking a point of order. I think what I'll do is have Attorney Pucci go through and talk about the scope and the town's position, and then of our review, and then we'll go to the architect who can further go through what about the substantial versus insubstantial change. And then I was going to go to members of the audience and or Zoom, so you'll be in that third category there. Sorry, Attorney Durensis, you need to go to the microphone because no one can hear you for the video. I think that for the purpose of this remand order, it's Surfside Crossing and a remand to us from the Housing Appeals Committee. So it's not, I think you're going to have your opportunity when we take members of the audience to speak.
I want to be sure I have equal time. Thank you.
Okay. All right, so I would like to go to Attorney Pucci at this time from KP Law, which is Town Council, to, for everyone in the room and in the audience and the board to give us direction on this remand order and specifically the scope of review. And particularly the point that Attorney Haverty brought up at the end about the whether it's an up or down on substantial, insubstantial, and we cannot look at, or the local concerns are outside of the scope of review, or whether that those local concerns are something that we should address.
Madam Chair, if I could just clarify, it's not an up or down or substantial or insubstantial. That determination has already been made by the Superior Court. The change is substantial. It's really just an up or down as to whether this board is willing to adopt the modification or whether it rejects the modification.
Right, so
If it
they've said
rejects the
it's-
modification, we wind up back in the Housing Appeals Committee, back in the
right,
process.
sorry,
that was
just different
previously.
terminology, but we've gone through this in the substantial, insubstantial seems to be the common determination, but your point, I get your point.
Thank you.
Okay, so Attorney
Point of order.
Attorney Durensis?
We object to your participation in this matter.
Okay. I think I filed a 286A a long time ago for this.
I was going to say, when we did the site plan review, which was the spring of 2023, you had filed a disclosure form at that point in time.
Right, so I get that,
This is about your participation in a misrepresentation. That is, you signed off on a statement that there was no pending litigation. I want to submit to you a document for the record. We want this in the record for purposes of review by the Superior Court of whatever you say here today.
okay. My understanding of that complaint was that was an acknowledgement by the board and that was vetted by town council, and I don't have any status update on that. But you filed a conflict of interest complaint about that?
Could I defer to Megan?
Yeah, I mean,
Hurd?
I really don't want to go off track, I guess.
You need to stop. You need to stop and step out of the room and let someone else take over.
I don't think that, well, town council can correct, but I believe when we've gone through this before, that we have, that it's the board members' decision of whether they are conflicted or not. And I would say if the applicant feels that I have a conflict and you want me to step out, then I will. And that's the standard that we've always said if there's the applicant doesn't feel comfortable.
Well, may I suggest until you get a ruling from town council that you step aside for the protection of the town and frankly for yourself, because a violation of these rules is a felony.
So Attorney Pucci, would you weigh in on this? Because I haven't heard any feedback from the town on this. And I mean, I'll do whatever the town thinks I should do.
Well, it really isn't the town. It would be your appointing authority.
So
You
the
can take
select board.
you can take the objection under advisement. If there's been a conflict of interest complaint filed with the Ethics Committee, you probably don't want to comment on that. You just want to have the Ethics Committee complete their process of review on that. If the basis for the objection is signing off on the regulatory agreement, as you noted correctly, Town Council Vicky Marsh, who's a experienced real estate attorney at KP Law, reviewed the regulatory agreement and advised the board about that before you or any other member signed it. The provision that has come up in that I've seen in various email exchanges has to do with developers' representations, covenants, and warranties. That section of the regulatory agreement, and they made a representation about. Well, the document speaks for itself. So the developer made a representation in that, which if the developer wants to explain that further, what the representation was, I'll defer to them to do it. Vicky did look at the regulatory agreement. In fact, the first draft of it was inadequate, and she opined on what was required before the board signed off on it. Basically, the board is an acknowledgement of the regulatory agreement between the subsidizing agency and the developer. What town council opined on were issues of importance from the town's perspective, which would have been maintaining the affordability restrictions that are required under the permit and the comprehensive permit law in perpetuity and monitoring requirements and things of that nature. So to sum up, Madam Chair, you have not requested from town council a formal ethics opinion on this issue. If you do that, we're happy to provide it. If you've been notified by state ethics, I have no idea. I'm not privy to that information. I would recommend, letting them complete whatever investigation they're completing without commenting on it. And if you feel comfortable, it's not the applicant's call or project opponents or anybody's call other than you and your appointing authority. If you feel comfortable sitting on this application going forward, you can take the objection under advisement and go forward with the proceedings.
Could I respond?
Well, I think I would take it under advisement and then make a decision once I'm contacted by the Ethics Commission as to what their feeling is on this. And if at that point, once I hear from them about the veracity of this objection, then I'll make a determination whether I continue to sit on it or not.
And Susan, while we're talking about it, are there any objections to any other board members sitting? We might as well cover that now. It's one of the first things I was going to say.
Right, I wasn't the only one who was listed on that.
Yeah, one of the first things I was going to say to you is it would be helpful to designate or just specify for the record who the voting members on this application are going to be. And then obviously anybody else who's not a voting member can participate if they're sitting, but it's always good on a 40B to specify your voting members up front, because there'll be, issues if somebody has to miss one of the public hearing sessions.
Okay, so at this point, the voting members are myself, John Brescher, Elisa Allen, and Joe Marklinger, and then we will need one alternate to step forward at when we vote, and that would be either Jim Mondeni, Lisa Botticelli, or Mark Poor.
It's always
Jim,
good to designate it in advance. Sorry.
I was going to say, Jim's not here today. Oh, he is? Oh, I'm sorry. I don't know how I didn't see. I thought you were going to be sitting over here for some reason. Sorry.
And Susan, can you just let me catch up to you? You said Susan. Who else?
So there's 4 regular board members, myself, John Brescher, Elisa Allen, and Joe Marklinger. And then we do need to pull up one of the alternates.
Madam Chair, can I?
Wait, hold on one second. Mark, wait, hold on one second. Mark, did you, and I'm sorry, I feel like Jim and Lisa were probably more vocal was all, but did you participate a lot in the original? Oh yeah, that's right. Okay. So I would think it would either be Jim or Lisa, and Jim, you had something to say.
Yeah, I think it should be
the same parties that we designated for Surfside Crossing. And we did this before, unless you're suggesting this is a brand-new project, which, if you're suggesting that.
I'm not suggesting it's a brand-new project, but I'm suggesting that it's a new remand, and I think we've got some membership. Like we don't, like Michael's not sitting on this one. I can't remember offhand if he sat on it before, but Joe, you weren't. Yeah, I mean,
Why
Joe's.
is Michael not here then?
No, he's here.
No, why isn't he sitting?
Because we're not sure how much time this is going to take, and he wasn't sure if he was going to, I mean,
Okay, sorry, Michael. I thought he was conflicted, or he's not participating.
he's not
because
participating.
Not participating because he didn't participate in the last.
In the most recent.
I don't recall who, I didn't look at that. I honestly, I purposely didn't pull out all my old stuff because I just wanted to hear what this, like, I wanted to focus on what this was and then the scope of this one and then dig deeper into what we were doing. So I just don't remember offhand.
Let me just say, I'm in favor of keeping the same members unless they're no longer on the board. And then that can be replaced with a new member.
Okay.
But this is it's either the same case or it's a brand-new project.
All right, well,
And if it's the same case, why wouldn't everyone who's been part of this the whole time and is familiar with it be part of the members who vote on this?
okay, well, let's see where we get with this, but
So
I get what you're saying.
I'm going to make that motion that we appoint, I don't know how to make this motion, but the motion is.
Well, it's going to be,
Lisa
it's,
Botticelli, you, me.
I think someone on
John
Zoom
and
doesn't have
Lisa
their mute on.
I made a motion.
Sorry. I think,
That would be the voting member. Everybody would sit, but that would be the voting member.
so say that
Yes.
again. So it'd be you, Lisa, Elisa, John Brescher, and me?
Yeah, which were,
Okay, so, but,
Then we didn't have alternates if.
but so what we were just talking about was an ethics violation that they're talking about that they've filed, not just against me, but against other members. So who are the other members that you filed it
The
against?
other members.
That's
what we're
that's what I'm trying to get to. So just, I don't want to get derailed on this too far. Who are the other
So if I
members?
could, there was a couple of points I wanted to make, but that was one of them. The ethics complaint
there's a
was
motion
filed.
on the
Yes.
table.
I know, Jim, but if we make a motion to have it be the same board, and then we're going to have,
Well, hold on a minute, Susan, can I interrupt?
yes, please.
I apologize, but I would keep this discussion with the board. If, I'd go ahead and have the discussion amongst yourselves. We don't need any speeches in the meantime about ethics complaints. If there are objections to the board members, they can make their objections, you take it under advisement, you go from there.
Okay,
I would recommend, as Jim's sort of following up, I'm not saying I disagree or agree with Jim about how he wants the composition of the board, but it is good, the process that you're going through right now, to figure out who your 5 voting members are. And remember, 5 voting members doesn't mean that whoever is an associate member sitting on it can't sit at the table and fully participate in the discussions. Just ultimately, they won't be able to vote on the application. And it's not a new project, it's a project change on the original project. I should specify though, quite a bit of time has passed since the original application, and that can happen often in a 40B project where you end up with a different board than the board that voted on the original project. Sometimes with the passage of time that can do that. So you're not necessarily bound to have the same members who sat on the original application and your original decision to sit on the project change. If you want to, it's certainly within your discretion to do that. But I do recommend you complete that process that you're discussing with Jim right now, and complete the process on your designation of the voting members. Then, any objections can be taken and so noted and taken under advisement. It can be part of the record, and then proceed with the hearing, because you have a lot of substantive information that you want to start taking in. You have a limited time
Yeah, I know.
to hear
Okay, all
this,
right, so
and you want to get to it.
Okay, so let's do the vote. So Jim made a motion, Elisa seconded to have the voting board be the same that sat on the original application, which is,
It
Yep.
can't be the same, because two of the members are gone.
right,
Ed Field
sorry.
died, and
No.
So
Jeff Thayer is
okay, hold
gone.
on. Everyone, my understanding is that I, as the chair, get to decide who is the sitting and voting board. That was my understanding. And George, you're telling me that's not correct?
I don't know. Do you have a special rule about that, or is it a customary practice? I'm not aware.
No, that's
Last year.
that's what, okay. That's what I thought we went through on this specific application 2 years ago. But if you're saying that the motion that's before us right now is acceptable, that a board member can propose what the voting board will be, then that's fine. I'm just
Typically,
asking
you would
for
have
clarification.
your eligible voting members, your full members that have been appointed as voting members, and then you would fill in any gaps with an associate member. It would be
Okay.
unusual to to replace a sitting voting member ordinarily with an associate member. So
Okay.
I would note that. So if you want to go ahead and designate the board as chair, you can go ahead and do that. And I don't want to
And then what do I do
intrude
about Jim's made a
motion making.
motion, but Jim's made a motion and it's been seconded.
So I'd go ahead and vote on the motion.
Okay. So that's what I just wanted to make sure I do this procedurally right.
And as
So-
Joe just pointed out, you can't have the original board
Right.
because you don't have two members that were on it.
Okay, I'll rephrase. So Jim has made a motion that and let me know if I'm saying this right, Jim, that the voting board members for this 2524 Surfside Crossing LLC remand hearing be board members, whether full or alternate, that sat in some capacity on this subject matter prior.
Yep.
Okay. So I will do a roll call vote for that.
Can I make my objection for the
Yeah,
record,
sure.
please? Thank you. I agree with Attorney Pucci's position that it is standard and typical that full voting members of the Board of Appeals would be designated to sit on any application, and alternates would only sit if those full members are not available. I don't think it would be appropriate for the board to change that policy as part of this. In particular, the board member that made that motion has shown a very long-term and very vehement objection to this project, has engaged in some activities that were not appropriate previously. So we would object to him sitting on this no matter what.
Through you,
I object to that
through,
and request that
Okay.
be stricken from the record,
No.
please. This isn't about personalities and having a personal
You-
attack from an
Attorney
applicant before this board
Attorney
is entirely inappropriate.
Durensis, you don't have the floor right now. You don't. This is, okay.
there's
So
a
here's,
motion on the table. They
here's
cannot object to it.
what's,
unless they're on
wait,
the board.
hold on 1 second. I just want to clarify for the audience. Attorney Haverty over here is the applicant. So the way that we typically hear matters before the zoning board, the applicant gets a chance to make their presentation. They didn't finish their presentation. I asked that once Attorney Haverty and Mr. Feely made their presentations, that then Attorney Pucci could present, and before we went too far into it, give the board, the audience, the applicant, the position from town council, our 40B council, of what our directive should be to move forward. We haven't even gotten there yet, okay?
Madam Chair, can I
Wait,
comment on
no,
something?
I'm not done yet, Jim. So what's happening now is Attorney Haverty still has the floor for the applicant presentation. I've told Attorney,
Object to that.
Yeah, no.
No, that's not part of his presentation. He's talking about a motion that was not part of his
okay,
presentation.
Attorney Durensis, you will have an opportunity after the applicant has finished their presentation, and I don't want to get into a back and forth. We're going to finish the motion that Jim had to
Madam
designate the
Chair,
board.
I just
Yes.
want to clarify. Nothing, I just want to respond through you. We don't have procedures set up for this board. We should. They should be filed with the clerk. But it's been the custom of this board to be a little more flexible on that, which is why I was on this to begin with. And we've never taken the position until now because of this, where the 5 voting members always vote and the alternatives only vote if someone's conflicted out. That certainly can change. We can vote on that, or you can make it your rule, but that has not been the way this board has operated.
It has been the way the board operates in the last few years. I agree it hasn't the whole time, and it
Only
wasn't.
because of this case.
I think this brought it to a head,
But
but we've done it that way since the vote on this case, which whenever that was, which I don't know off the top of my
The
head.
original case, though, Jim was an alternate, as was Jeff, and they sat on it and voted.
Yeah, I think because we didn't have Mark, we didn't have maybe Michael, I don't know.
Well, I would
Anyway,
recommend in the future that we come up with procedures for this board that gets filed with the town clerk, which is what we should have done or what should have been done years ago. And that'll set it in stone as to how this board operates.
Okay.
But we can't change the operation of the board based on who's presenting the case or who's behind it. And that's what we're doing here.
No, because we've been acting the same way consistently since we became aware, or since I became aware, that the typical procedure for zoning board voting is that it's the full members unless the full members can't vote. So
We
can discuss that, and if we want to do
agree.
procedures, that would be great. I would love that, but I don't know who drafts those or how that happens, but that's not the discussion we're having now. We have a motion on the table that has been made and seconded, and I'll do a roll call vote for, again, that the voting members on this application would be myself, John Brescher, Elisa Allen, Jim Mondani, and Lisa Botticelli, correct? Okay, so I will do roll call again. Elisa Allen? Aye. John Brescher?
Aye.
Joe Marklinger? We're voting on whether you are a voting member for this application or not.
So if I is for me? Or
And I
is
would be
Jim?
I would be for the typical process where the regular full members
Right,
vote.
that's what I'm for. I don't quite understand what,
Okay, so we have
No, but he's voting nay on the motion.
I'm voting nay on the
nay
motion,
on the
yeah.
motion.
Yeah, just making sure.
All right, so
Thanks, Lisa.
Elisa, you were a yes. John Brescher?
Aye. Yes.
1, 2, 3. Myself, nay, and again, I have to pull up a alternate, and Jim.
Aye.
Okay, so that is 1, 2, 3 yes, 2 no, so that motion carries. Okay, so the sitting board will be myself, John Brescher, Elisa Allen, Jim Mondani, and Lisa Botticelli. Okay.
One last comment about
Sure.
this. I'm not against the process you talk about.
Yeah.
It depends on what period of time you're looking at, but we've not operated that way until certain cases come before us. And I'm all for having the full board members vote on everything.
And that's what we do,
alternate
that's what we do.
Well, then we should document it or vote on it or something. That's all I'm saying. I'm not
I don't think we have to vote on it, I think that's the process, but.
that's fine.
But okay, we can talk to town council about that offline and make sure that it's clear. Okay, so I would like to hear from Attorney Pucci about, again, the the remand order, the scope of review, and the directive from the Superior Court through the Housing Appeals Committee.
Yes, thanks. I'm going to speak as little as possible because we've just spent 50 minutes on that before we get to any substantive comment. The scope of the remand, there are comprehensive permit regulations that are quite clear about the scope of the remand. It's pretty much limited to the project change. However, there's a couple of unusual instances here. Number one, there's quite a passage of time between the time of your original decision, that full HAC process, and now that the matter is back before you. So there may be changed circumstances that, as a practical matter, you've got to start looking at some new information. I would imagine that the applicant is going to, try to address anything, that's changed over the course of time. And I should note the long passage of time is no fault of the zoning board. The zoning board, through me, counsel at the time, had argued vociferously to the HAC that they should send back that project change from the mix of single-family homes and condo buildings to an all-condo development. We had argued that had to go back to the board as a substantial change. The presiding officer in the HAC proceedings disagreed with that, and they went forward with the full appeal process and a decision on your original comprehensive permit decision. So all the length of time that has passed, it is really the result of the position, quite frankly, that the applicant took in the process, and also the HAC presiding officer agreeing with that position, which now we know, according to a Superior Court judge in Nantucket County, ruled consistent with the argument that we originally made, that this was in fact a substantial change that required a public hearing by the zoning board. So that's the reason for the long passage of time between the original decision and where we are today. The scope of the remand order, which has now come to you from the Housing Appeals Committee as ordered by the Superior Court, is quite broad. So I don't intend to get into technical legal issues with you at this point. I'm going to be with you for this process and available to answer any questions that you have. The remand order is on pages 7 and 8 of your packet. As Attorney Haverty noted, he read from various aspects of this. The issues are quite broad about, your scope of review of this project change. And I think that you have to address it in that manner. At this point, what I'd recommend is you start to take substantive information, both hear from the applicant about the changes that were presented, how, if any, those have changed from the original decision that you made, how the project has allegedly improved as a result of the project changes, and then that you hear, town department comment on issues. If you think that peer review is required on certain technical issues that would provide assistance, I recommend that you start that process. Obviously, you're going to want to hear from project opponents, what they have to say in response to the project change. But again, it's for, you can read it more easily than I can summarize it for you, because it's only 8 sentences long, basically, the scope of the remand order. But it's, again, quite broad. It deals with things like on-site and off-site traffic circulation, building height, open space on the premises, all these types of issues of local concern that would have been within your province when acting on the original application. So I would recommend very strongly, as you start to get substantive comment to you on the project, start to be able to formulate issues and questions that you might have on the project, and then I'll be able to available to assist and guide you as we go forward if technical legal issues come up in the process.
Okay, can I just ask one, I just have one question about, okay, so Attorney Haverty mentioned that the local concerns were already ruled on as those are outweighed by the need for housing. Is that part of it open again?
Yeah, I think what you need to do is look at it in the context of you're examining the project change in terms of issues of local concern. So
Okay.
you're not precluded from going into these issues because there's an HAC ruling on your original decision. And again, that's no fault of the board. The fact that the HAC went ahead, had a full evidentiary hearing, and then issued a decision is not now preclusive on your ability to apply, issues of local concern to the project change. And that is actually reflected in a pretty broad remand order to you. So don't take issues of local concern or bases that you might have been thinking about on your original decision as precluded now in this process. Obviously, I would recommend not simply reissuing the original decision that you had. I think you need to take a fresh look at this and look. And again, your review is limited to impact by the project change. Has the project gotten better? Has it raised further issues? Has the passage of time made it necessary for you to look at certain technical issues with regard to the project as it now exists at this time? Those are all going to be questions within the scope of your review. But I would definitely recommend taking, and the applicant's free to object to this if they want as we go along, but I would recommend taking a pretty open look at this. And if I think you're getting too far afield or you ask me a question, if it goes beyond the scope of the remand, I'm happy to provide that information for you. But I would err on the side at this point of seeking all of the information that you find relevant on the issues before you.
Okay, thank you.
Madam Chair, can I have a question?
Sure. You have a question for Attorney Pucci?
Yes.
Okay.
It just, before we get into the nitty gritty, I think when I viewed the court's order, it's different from the HAC. And I just want to know what you think of that, George. It isn't even remanded to the HAC. And the HAC's remand order is, to me, very different than what the Superior Court is. The HAC's, once again, I think, overstepped their boundaries by deciding what we can review. The judge in this case said that these changes cumulatively amount to a totally new or different proposal. And this error in law that the HAC made requires reversal of the substantiality and remand to the board for consideration of the altered project in the first instance. So what is the first instance?
Yeah, that's what I'm saying. It is quite broad. And I don't really think the HAC remand order is inconsistent with that, because basically what the Superior Court is saying is what I was touching on before is that you have a pretty wide range of issues now that you can look at on this. The issue of substantial versus insubstantial is over. That determination was made by the court. In other words, if it had been before the board, before it went to the HAC, you would have made the determination, is this a substantial or insubstantial change? If you found it insubstantial, it would have been deemed so modified. If you had found it substantial, it would be subject to a full public hearing. Same thing at the HAC level. If the HAC had originally ruled this is a substantial change, the presiding officer would have sent it back to your board to hear the project in the first instance, the project change. And that's what you're doing here. Essentially what happened was the HAC didn't make that ruling. They went through the full proceeding. They overturned your original decision, issued a new permit. But then subsequent to that, the Superior Court found that that was legal error on the substantial change determination and sent it back to the HAC to, issue a new ruling consistent with the judge's ruling. That Superior Court decision would have been subject to appeal. The developer did not appeal the Superior Court decision, so that is binding on the HAC and on these proceedings. But basically what the judge did was essentially determine, as you just read, this is a substantial change under the regulations. It should have been heard by the board in the first instance. HAC reissue your determination consistent with my opinion. And that's what the HAC did. So you're looking at this in the first instance.
But the HAC limited it, correct?
Well, you'd have to specify that though for me, Jim. I mean, what issue are you seeking to look at that you think is not within the scope of the order? I think you need to think that way as opposed to saying, well, the HAC remand order is not consistent with the Superior Court order. As I said before, the remand order is quite broad in terms of the scope of issues before you. So if you can think of an issue that you think does not fall within the scope of this remand order, I can opine on that, but it's hypothetical at this point till you start to get into the issues and the questions that you have about the project change.
Madam Chair, I think.
Yes, Lisa.
I mean, if I'm reading this right, the only items, it feels like we can talk about the size of the buildings, the type of buildings, the number of them, the location, increase in building heights. I mean, when you read the order, there is very broad. One thing they don't talk about is impact of sewer use and water use. That's not listed as one of these items that we can talk about or that are up for discussion, but I'm presuming that that is based on your interpretation of, technical issues due to the passage of time that we should be able to discuss.
Yeah, through the chair, Lisa, I think that's very reasonable. I mean, I think you need to hear from the applicant on it. What is the situation now with water and sewer? What do they have proposed? What's their technical analysis? What interactions, if any, have they had with town departments? All of that. I think that it's definitely reasonable for you to look into those issues because, again, there is such a passage of time that makes this remand a little bit unusual. It's not as though it was remanded in a timely manner to you so that conditions were all exactly the same when you acted on the project change. I do think it's reasonable and within the scope of your jurisdiction on this project change in light of the passage of time to go into those issues and then see where they go. If it then gets to a point where you're receiving opposition to the scope of your inquiry, we can deal with that then. But I definitely think at this point, it is well within your jurisdiction to be looking at those issues.
Thank you, George. I have one other question, and I don't know if this is to the staff. In years past, we have had consultants. We've had some money designated by the town to hire consultants. Do we have that established at this point?
We need to establish that during this procedure. So that'll be up to the board. I mean, we can definitely put in for an engineer consultant to do a peer review on this if the board is if that's what the board wishes.
Okay, thank you.
Madam Chair, this is what I'm getting at, and this is what I disagree with our counsel on, is that the judge went through in detail what the problems were, but when he remanded it, he didn't limit it to those things, and I think he would have. So I think the discussion between the judge's order and the hack order is appropriate because I understand the judge's order as a full new review, hiring new engineers to review it. It's a new project. This got jammed down our throat last year and we didn't have counsel. And now I think it's appropriate to go through. That is what the judge is saying. And that's a difference. And I'm sorry, I'm going to bring this up. We have counsel on this that is very conflicted in this. He's advising you to go with hack when he wasn't part of the lawsuit. Even though this town was part of the lawsuit, he did not show up at court. Their firm did not show up at court. Their firm did not advise us on this last year we went through it. And now they're stepping in. They're going to advise you on the conflicts, which they're so conflicted out of this. I don't know who George, who his real master is. Is it the town? Is it the select board? Sometimes he comes in to us. I mean, I don't want to rehash all this, but I'd like to make the motion that we obtain separate counsel to advise us on this and to have the law firm recuse themselves from this case. Because his interpretation to me is not correct at all.
Okay, so I think we've went through this exercise
Well,
before.
what is the interpretation that's incorrect? I just
Wait,
agreed
George,
with you.
George, before we get into a back and forth, we went through this exercise before about the board hiring independent counsel, and we do not have I believe we do not have the authority to do that. That we need to ask the permission of our appointing authority, which would be the select board. So if that is something that the board would like to do, then we can entertain a motion to do so.
And let me follow up on my motion is, why would we vote against this? This is another council. I know you're worried about what Libby's budget and all that, but why wouldn't we why would we not accept separate counsel?
I have no
on
idea
this?
about
And
Libby's budget, and that's
I'm
not.
saying fellow board members, why wouldn't we, if it's an ask, let's ask.
Well, that's what I just said, we
Because
could
I
entertain.
really think they're conflicted out. And George, to answer your question, there is a difference. I don't want to get into it. I mean, I know you're legal counsel on this, but what I hear you siding with is a developer in saying that the hack only wants you to look at these decisions. I think the hack's decision is totally moot, and it needs to be addressed with the court, and to have the court bless that before we do. But you all are going down the path before we even have a chance to determine what we're supposed to do.
So George, or maybe even Attorney Haverty, is the hack remand decision, is that filed with the Superior Court to ensure that it meets with the ruling and the remand that the Superior Court issued to them? Or is that just, they got the order to send the remand to us, and it wasn't appealed, or what, how did that work? How did we get to where we are now?
Yeah, they complied with the Superior Court order. Nobody filed for further relief with the Superior Court that they didn't comply. I think it's important to, here we go. I mean, I tried to be polite when people were making conflict of interest charges and just saying, look, take it under advisement, it will work itself out in the process. I respectfully take exception to being accused of having a conflict. And first of all, serving a master, not to pontificate, but, my mother didn't clean toilets to put me through law school for me to have a master. I don't have a master. I'm town council. I was engaged by the select board, your appointing authority, to advise you on this. You had sought separate counsel before when the select board wanted to dismiss the lawsuit that I filed on your behalf, and the select board denied that request. You're free to make a further motion today if you want to ask your appointing authority to appoint special counsel for you. But, and that's perfectly appropriate and within your right. This is America, you can make that motion. But I don't appreciate, being charged with some type of conflict of interest or anything like that. I'm advising you to the best of my ability based on what's before you. And I still don't hear what the substantive basis for your disagreement with my advice is. As Lisa just pointed out, and I agreed with her, the remand order is very broad. And she brought up issues that are, not within the, exact wording of the remand order. And I just agreed with her that it's totally within your jurisdiction to delve into those issues. So it would be nice to just hear some substantive information about what it is about your inquiry today that you're confused about, whether it's within the scope of your jurisdiction or not. Because so far, all I've told you is it's a project change. It's already been deemed substantial by the Superior Court. The Superior Court agreed with an argument that we presented many years ago. before the select board decided that they wanted to dismiss that lawsuit. And you've got the matter before you. And I keep recommending that you get to substantive input on this project change that's before you. So, it would be nice if we actually heard some substance of what it is that you're telling me that you're confused about this within the scope of your review.
George, I respect your legal expertise. I just say, and the terminology I'm using is used, I don't know, within the legal world about serving two masters. I don't mean it literally, and that it just applies to you. It's terminology that's used when a lawyer is conflicted, and it's not an explicit conflict. I just think that you went with the select board against us, maybe not against us, but you went with the select board, and now you're back in representing us, and I just don't think you can represent two bodies that differed on an approach.
Yeah, Jim, I appreciate that. So if you want to go ahead and make the motion, I'll be sure to notify the town manager if it doesn't get over to them, to make sure that if the board votes that it wants its own special counsel on this, you're free to make that motion. If it gets voted by a majority, it'll go to the town manager and the select board, and they can make that decision. So I appreciate that. If you want to go ahead and make that motion.
Okay. And my other thing about the conflict, George, is that we were still a party to that suit, even though select board took themselves out of it. The town was still a party, yet we had no representation in the suit. Just want to note that. And
Yeah,
I'm
that's not,
sure
we'll
why.
have to agree to disagree about that you were notified before. Thank you.
So my motion stands.
Okay, so I'll do a roll call. So
Is it
this,
seconded?
oh, sorry. So did someone make a second on that, Lisa? Oh, you didn't, sorry.
Can I hear the proposed motion again? Sorry.
Oh, so that we, I guess it's more,
Request, right?
a request
To the Board of Select, or the
Say
Select
whole-
Board
say
to,
the whole motion.
that we make a request to the select board that we obtain special counsel or separate counsel.
I would say explore the idea of second counsel. Okay, we can request. I'll second.
I think you have to request it only because we need the funding
Yeah.
to
yeah,
be
yeah.
able to then
Okay,
explore it.
Yeah.
If
okay.
they're going to say you can't have
To
any funding,
explore,
there's nothing
yeah.
to
Okay.
explore.
All right, so Jim made the motion to request to the Select Board to obtain special counsel for the Surfside Crossing LLC 2524 remand review. Lisa Allen seconded that motion. I'll do a roll call. So Jim,
Aye.
Elisa,
Aye.
Lisa,
Aye.
John Brescher,
He stepped off at
he's
2
up.
p.m.
Okay, so myself, I, and I guess I'll, yeah, and Joe.
No.
So who do they want off the board?
Well, we're not there
We're
yet.
not there yet.
I want to hear from,
It's a rhetorical
kinda
question,
getting-
kind of. It's interesting, isn't it?
Yes.
did I miss here? Oh, Lisa, okay. Okay, so that request will be made to the Select Board, and we'll get an answer on that, and then move on from there. So at this point,
Can I ask George one other question?
Yes.
Before we lose him?
Yep.
If we render a decision and the applicant appeals our decision, where does it get remanded back to? Does it go to Superior Court or back to HAC?
You said before you lose me, I'm not going anywhere, but.
Oh, okay. No, I didn't mean it like that.
Oh,
I'm
thank you.
not suggesting you go anywhere.
Right. Yeah, that would go to HAC, the applicant's appeal of your decision. HAC's decision would then be also subject to judicial review as it was first time. But the applicant's initial appeal would be the HAC.
Okay.
So Attorney Haverty, as you said before, Pucci and then go to your architect.
Yeah, I hesitate now, but I just did want to address a couple of the points that George brought up.
Sure.
with
Why don't we
regard-
just briefly, and then I
Sure.
really want to get to the architect to hear more
Absolutely.
about the changes.
I'll limit it to this one point.
Okay.
With regards to the remand order from the Housing Appeals Committee and the decision of the Superior Court, if this had come to this board initially, rather than going through that process, we had come in with a modification, you are subject to 760 CMR 56.05 subsection 11 subsection C. And that states, only the changes in the project or aspects of the project affected thereby shall be at issue in such hearing. So again, irrespective of how we got here, this board is subject to the provisions of 760 CMR 56.0511C, and your hearing is limited to the aspects of the project that are affected by the modification. Everything else is off limits. I agree that the remand order issued by the Housing Appeals Committee is broad. And it is broad because there are a lot of moving parts when you compare this to what was originally filed. And everything that changes from the original project to this project that has an impact now that wasn't there before is within your scope. Everything that doesn't have an impact now or has a lesser impact than what was originally proposed is outside of your scope. The issue with regards to traffic, off-site impacts, on-site, it's changed. You need to review that fully, I understand that. Off-site, there's going to be a reduction in the number of vehicle trips, and that has been established by the testimony we submitted from our traffic engineer. There's no need to do any further review of off-site impacts because they can't get worse. They're only going to get better with the reduction in the number of vehicle trips. It doesn't
Okay,
matter.
okay.
It doesn't
Everyone will
matter
get
if
their
people don't agree
turn.
with it. It's the fact, and absent any evidence from a legitimate professional traffic engineer that would indicate that there would be an increase in off-site traffic, that's not an issue that this board should be considering. With regards to some other issues, the sewer and the water, the impacts are lesser. Now, there is, again, Attorney Pucci pointed out, it's been a long time, there may have been some changes. We're not going to object to some sort of update on the sewer. But at the end of the day, the impacts for the modified project are less than what was originally proposed.
Yeah, could I have a
Okay,
question?
wait, hold on, I just want to clarify, Attorney Haverty, you're saying that our review is limited to the aspect of the project affected by the modification. The modification is determined by Superior Court and sent back to HAC as being substantial, which was what the zoning board had argued in the first instance when we had this plan. And I think the aspects of the project affected by changing it to 156 condos is very broad and gives us, and as Attorney Pucci said, we review in the first instance. And I think we just need to get into, let's hear from the architect about what those aspects of the project are, so we can start pulling out what we want to spend more time on. I believe we have to close the public hearing as of January 31st. And our action deadline from, if we close it January 31st, is 40 days from there. So this isn't a lot of time.
No, I understand.
I'm not just talking to you, but for all of us, like, it's not a lot of time. So I don't want to gloss over it, but I think let's try to hear some of the substance so that we can then start asking questions.
Well, I have a question
Okay.
about what he just said.
Okay.
You refer back to the original project. Is that the original project as approved by us, or the original project as submitted?
As originally proposed.
Okay, right. So I think that those are two different things, and I just wanted to make that clarification, that I think our original approval is significantly different than what you're proposing now, and that is a change to the project. That's how I interpret it.
Except for your original approval never took effect because it was appealed. It's gone through, multiple processes since then. The
Right.
question, which if the Housing Appeals Committee, in, hindsight being 2020, we wish they had, although we argued in the alternative. If they had remanded this to you back when we had submitted the notice of project change, it would be a very clear process, which is you're reviewing the modification and comparing it to the project as originally presented. There's a project that's in front of the Housing Appeals Committee that we appealed, and then, by which I mean the originally proposed project, and then there's the modified project. That's what you would be reviewing, and your up or down decision wouldn't necessarily be to approve of the 156 unit project. It would be whether you agree with the modification or disagree with the modification.
So are you saying that that we can go back and compare this? So we're not looking at when you're saying original project or proposal, you're talking about the original 156 units.
Correct.
6 structures, 16 each, and then 6 structures with 16 units each, and then the 60 individual single-family dwellings.
Correct, because that was what was pending before the Housing Appeals Committee, before we filed the notice of project change.
I feel like there is enough language in there, there is enough language in there that gives us the latitude and the ability, because of the minor or major changes and how it affects other aspects of the project. We're going to get to that. I think talking about what's within our parameter right now we're wasting time. We have to see the changes and decide how it impacts the rest of the project. The end, I don't want to talk about it anymore. It's loose enough that we're going to make those decisions, and you don't need to direct us anymore on that.
Well, and
And I'm fine with that.
and like George said,
Let's move
if
on.
something comes up that's outside the scope, or we think it might be outside
We'll
the
discuss it
scope, we'll
then.
find out then. Okay.
And if you get to something that's outside the scope, I'll be sure to object. But
Right.
In the meantime,
I'm
let's
sure
just
you
move
will.
forward.
Well, you might
All
not
right.
be allowed to object, but let's keep going.
Yes, so let's hear from the
So let's hear
architect.
from Andrew now.
Yeah, I think that's what we should do.
Hello, everybody. Assume you can hear me.
I have 3 people speaking, maybe 4 at once. So, well, one of the board members was speaking first. So what did you have to say, Jim?
I just, on the, specifically on the traffic, this is for you, Attorney Haverty. So you're saying that's not within the scope because it's, your traffic study showed that
In the absence of credible information from a traffic engineer that would show that there would be an increase in traffic because of the reduction of bedrooms by over 100 bedrooms, which I don't think you will be able to get an actual traffic engineer to make that argument. That would be inconsistent with the ITE trip generation standards. But in the absence of that, my position is that off-site traffic is not part of your scope.
But how do we
It might be.
determine that it's not?
Well, I think once we get a consultant, we would then we would have a consultant and see,
Okay.
and
Yes.
just, and double check the numbers, like,
Right.
trust but verify, right, or whatever.
We'll
like-
have
He's
peer
saying
review.
that's
Right.
not our scope, right?
Well,
He can
he's
say
saying
that
it's
all he
not, but
wants.
we could show that it is, because the same as the water and sewer usage,
impacts.
it's sort of, I think, an attendant impact from the change. And like George said, we're talking about such a long period of time. I don't know, I have no idea, how long is the efficacy of a traffic study? I don't know. If it's been
gonna
over
find out
a
when
couple of years, like maybe.
Well, certainly from the original application, it's been 5 years.
Yeah, so we'll,
So, I
again,
think
that's
it's
one of those
worth-
things I think that we would ask for, he'll object to, we'll figure it out, and if that ends up being grounds for an appeal later on his end, then that's an appeal on his end, like, we can't do anything about that, but we can see if we can get to,
Okay, so I
Getting
just don't
traffic
want to be
information.
foreclosed on making that request.
I think we can, I think the same as council, we make the request, and then it's I don't know who determines, I think it's our appointing authority, but I'm not certain, someone determines whether we get to be able to do that.
We've already made that request though, right?
Yeah, so we'll,
For a peer review person like a
yeah,
John
That's what
Chesney or something.
And Madam Chair, we are certainly not going to object to this board going to a qualified traffic consultant, asking them to consult the ITE trip generation manual and make a determination as to whether the reduction in 100-plus bedrooms is going to result in an increase or decrease in traffic. We're quite confident what that result will be.
And Susan,
yes, George.
I just heard somebody said something about a request going to the select board. No, peer review will.
I did, I probably misspoke.
No,
Yeah, if you have issues that you want peer reviewed, you're going to seek funding for that from the applicant.
Oh,
Yeah, they are.
But I know, I mean, I just didn't know how I don't know that process, how we did that before, but okay, great.
It's very simple. As you go through this process, you identify issues that you think you need technical assistance on that can't be answered through your existing department heads. And then you specify those issues, you make the request to the applicant, and typically they'll cooperate on that. If they don't, we'll deal with that then. Then there's procedures to deal with if the applicant objects to funding certain peer reviewers. But you're going to need to identify the issues that you're looking at and then take it from there. That's what you did last time. You had several peer reviewers that were working for the board, but were funded by the applicant.
Okay, great. Thank you for clarifying that.
And Madam Chair, my only response to that would be that there was peer review conducted of the final plans during that process last year. So I would request that the board use that same peer review consultant and have him consult those in order to keep those costs down, as is required under the regulations.
All right, again, we'll have to look back and review all that and see what we want to do. Yes, Attorney Durensis.
I object to the procedure that you're following here. You're having the applicant's lawyer give you legal advice. We're recognized by the Superior Court as a party. We're entitled to also respond to the legal advice, give you perhaps different advice. We're representing residents of Nantucket. If you read the Superior Court decision, they acknowledge that we have standing. And I have many comments. A lot of what I don't agree with, a lot of what Mr. Haverty's advice to you is that needs to be responded to. We're here. I'm here to give you counter advice and cite you counter law that allows you to do things. But you're having these dialogues go on only with the applicant's counsel, and Mr. Pucci has to interrupt you in order to be heard. I object to the procedure. I want it noted for the record. Again, this is all going to be reviewed by Superior Court. So please note my objection to how you are conducting this meeting. And secondly, I want to make a comment for George Pucci's benefit that the nature of the ethics complaint is that there was a piece of paper that was reviewed by your office and it contained a false statement. So to some extent, your office may be a witness in this matter, either in Superior Court or before the State Ethics Commission, and that you should consider that in connection with the request for counsel.
Okay, all right, thank you, Attorney Durensis. I don't think that, and I just want to clarify, I don't feel that I'm getting legal advice from, or I don't know if you all feel that. I feel that, like every other applicant that comes before us with an attorney, he's making a presentation on behalf of his attorney. The attorney that's representing the board, the town, and giving advice that I'm taking as advice is George. George, if you feel that you haven't given an opportunity to speak and you've had to interrupt me, I apologize. It is a challenge to run a meeting with a screen behind me when I can't see, I don't have access to see people's hands up. If George was sitting in an audience, I could see body language. I might see that he wants to speak. So again, Zoom is a great forum to give us accessibility, but it is a challenge to effectively running a meeting, and some of the nuances that you get when you're in person are lost. And so that's not my intention at all. And clear lines of the applicant and the applicant's counsel, the board and the board and the town and the town's council. I can't speak to how the Superior Court thinks that you should be participating in this hearing, but you're representing members of the public, right, against an opponent to the applicant. Again, the applicant makes a presentation, the board can ask questions. When that part of the meeting is finished, then we go to the public and other members who are either pro or against or have questions. Once we get to the architect, who's part of the presentation, then I'm going to move on to anyone in the audience, either in person, on Zoom, and you are front and center on that, as I said at the beginning of the meeting.
We have an entire presentation with many
Perfect.
witnesses. We're going to need some concentrated time, not randomly you selecting various people from the public, but a presentation.
I will select people from the public however they raise their hand on Zoom or in the audience, as I do for every meeting. And I've already told you now, this will be the third time, that when I open that section after the applicant has made their presentation, you're first on the list. I already said that. So I don't know what else I can do. Like, the applicant is going to finish their presentation, and then you will give your presentation. Okay? Okay.
Madam Chair.
Yes.
Can I ask George a question, please?
Sure, and then yes.
Okay. George, I just have a question related to this litigation that's going on between the parties. I don't think it's resolved yet. And we kind of jumped the gun last year before it was resolved, and then it appears part of it's resolved. And here we are again. Does it make sense that we don't really review anything until that litigation is resolved?
I don't know what.
Are we
Yeah.
at risk of it getting appealed in some way, and we're back here again reviewing a new set of guidelines?
Oh, for sure. Your decision here is going to be subject to appeal if somebody decides to appeal it. Project opponents, if they're not happy with your decision, can appeal to court. And the applicant, if they're unhappy with your decision, can appeal to HAC. And yes, it could end up back before you. But I'm unaware of any legal proceedings that prevent you from going forward with your remand hearing. In fact, to the contrary, you would be acting at your peril not to go forward with the remand hearing.
George, if we miss that, if we don't close the public hearing by January 31st, 2025, or
you'll want to, you'll want to be able to close by that deadline, or get an extension granted by the applicant. If they agree to it, you're free to do that. HAC would have no problem with that. We'd file a just a notice with the HAC that it was extended. On that point, Susan, I'm sorry, go ahead. I
was going to say, if we didn't move forward, would we be at risk of a constructive grant?
Yes, absolutely. Okay. Yeah. They'd be able to go right back to the HAC and get it. You're going to want to act on this. Yeah. A couple of things on that is, we argued for more time when we had the conference with the HAC after the order from the Superior Court. I asked for the typical 6 months that you would have for your regular public hearing on the 40B, and the HAC presiding officer denied that. And he set the deadline for January 31 that you have. So that would be what I would recommend strongly you go under. If it ends up that the applicant agrees to an extension, fine, but I would err on the side of treating that as your drop dead deadline to close the public hearing, and then you'll have 40 days to issue your decision following the close of the public hearing.
Okay. So does that answer your question, Jim, about, yeah, okay. Okay,
Madam Chair, I just wanted to make a clarification regarding our presentation.
sure.
After Andrew Cochin, we do have Don Bracken from Bracken Engineering to present the civil.
Okay, all right.
And then we'll be
Sorry,
finished.
that's, okay.
Thank you.
So let's finish the applicant's initial presentation for this first meeting, and then we'll move on to Attorney Durensis and the members of the public. Is he on Zoom?
Madam Chair, I am here.
Okay.
And Andrew,
I
you
will-
have the ability to share your screen. I think it'll be easier for you to do that.
Yes, great. My name is Andrew Cochin. I am representing Workshop APD, the firm that was engaged to design the project at Surfside Crossing as a 150 unit condominium development. So I will share my screen and review an exhibit, which is, I believe, labeled Exhibit 2, that was submitted to the board and I believe is public record. I'll try to zoom in so people in the audience can see everything. We've created a comparison here on both sides. Much of this has already been discussed over the past hour and a half, that the original submission for the project was 6 16-unit condo buildings with 60 single-family homes. The project that's in front of you today is 18 condominium buildings with either 8 or 9 units in each one of those buildings. When Don Bracken comes back, he can speak more to the sewage and other technical elements to the site. This in front of you now is the original submission that was made as a 156 unit development that had 60 homes and 6 condominium buildings as previously just articulated. This site plan was just a different design approach to the site, but had sort of 3 entry points off of South Shore Drive and sort of compartmentalized the condo buildings against the residential units. The architecture of those buildings, while very nice, was more of a mostly 2-story massing configuration, sort of creating a more dense bulk massing review to the context, and the approach we took was somewhat different. So in this exhibit are those documents to support what the previous submission was. Our design it had a slightly different program, knowing that we were going to the condo buildings. As I said, there's 18 of them. There's a few different types that I'll articulate on the next page. And our approach was to create a very cohesive community. Having worked on Nantucket for over 25 years, I felt like we wanted to bring a different scale to the architecture that was to be implemented into this site, and have sort of a singular arrival into the property that was surrounded and prioritized community open space. So the entire center portion of the site is a community building with community outdoor space. And that outdoor space weaves its way through each one of these sort of micro blocks that are sort of 2 packs of units and 1 pack of units with parking in between. That again, Don can speak more to the technical aspects of that. But for us in the design, it was again, the outdoor space, individual green space for every one of the 156 units, whether it was on an elevated terrace, a terrace below grade or a terrace at grade. These are the unit types that we have. We essentially have 3 unit types in the project. Some of them mirror their way around the site to create more variety. And each one of them is made up of 2-story above ground massing configurations and single-story massing elements integrated into them, with generally a 30-foot, 10-inch ridge height above the existing grade. The architecture was intended to be very Nantucket. This is a residential project not far from this site that was, again, this mix of 2-story and 1-story elements with natural trim. In this pack, it gives you a sense of the architectural language itself, very much embedded in the Nantucket fabric of shingles, white cedar, some shiplap, asphalt shingles, Ipe decking, all things familiar to everybody. Additionally, as a way to create variety within the architecture, we were mixing up sort of our window configurations, knowing these are things that are oftentimes discussed within the HTC on Nantucket. So we have 6/1 windows, 2/2 windows, and all of those make their way and mix throughout the entire project site. The landscape intended to be extremely natural, weaving pathways and grasses into it, trying to really capture that open space between the architecture to make it feel as natural as possible. Landscape elements were asphalt, concrete pavers, curbing, steps, gravel, all things indigenous to Nantucket. This gives you a little bit more of a blow up, showing the relationship when there are these two packs of the condo units themselves. I think it's important to understand that each unit has its own individual entry to it. There's no sort of common hallways that you would typically see in larger apartment buildings. This is something that we feel would be more appealing to the end user. And like I said before, each unit has either terrace space, sunken terrace space, wrapping around it with really great connection to the outside. And the massing, as you can see, is broken up rather than sort of these large boxes. It's broken up into smaller pieces, the additive massing component that is supported by building with Nantucket in mind. And then each one has sort of a parking area adjacent to it, reducing the sort of traffic that exists around the property. And then we've left, as large as we can, pretty significant buffers along the property edges of the site to the adjacent neighbors. These are some of the renderings. These have all been around for many years. I'm sure everybody's seen them, but they give you a sense of the variation in the architectural mass and scale within the context and the way it sits into the landscape, where almost every building always has a one-story fronting mass to it, within the two-story mass is set back towards the rear. And I'll just click through these to give everybody a better sense. The trim was intended to be natural, less maintenance long-term. Again, you see the very natural landscape rolling into each one of the buildings. And then from a distance, you get a better sense of the space between the architecture. That again, that open space was something very important in the way we were designing this project. And then here you get a sense from the side, the way the sort of three pieces of the architecture come together, really sort of low slung eaves, something that you'd often see in some of the surrounding contexts on the island to really engage the architecture to the landscape. And then here you get a sense of these lower levels that we have. This is one of the ways we were able to sort of reduce the mass and bulk on the property, was to create units that were sort of sunken into the ground, with sort of sculpting the landscape down to them. And here is the amenity building in the center of the site that has community space for all of the people that would ultimately live here, a pool, gym, and then tremendous open space and almost a park-like condition on that side of the property as well. So those are the high-level aspects of the architecture. I'm not going to get into all of the technical differences from building to building, but it gives you a sense from this original chart of kind of the real difference by the numbers between the two projects. And I'll turn it over to Don Bracken to sort of walk us through some of the other site components.
Thank you. Don Bracken, Bracken Engineering. As you know, I've been the project engineer from the beginning. The original plan that's up in front of you, we looked at that plan and we looked at the most current plan, and I have a brief description of what some of the changes are. Andrew touched base on a lot of them. First thing I'd like to say, though, is that the current plans that are submitted in your packet, they're the same plans that we reviewed last summer, that went through that rigorous review with John Chesia. We made a lot of technical changes. We came up with the final plan set. That final plan set is what was used to start the construction of the project, as you all know. The construction for the project stands at all the infrastructure is pretty much in place, the drainage, the water, the sewer, a couple of parking fields have been paved. I know there are some questions about the sewer and water capacity. We already have the water connection. We have 2 connections out in the road to serve the site. You may recall during the original discussions about whether there was enough capacity or not capacity, there were issues about what the town has for approved capacity with the state, but the town's consultant determined that there was adequate volume and adequate pressure to serve the site. And as mentioned earlier, there's less water usage proposed now than there was at that time. In the sewer, there's been some big changes in the sewer. If you recall, the sewer was a big issue as well because we were proposing to tie into sewer force mains that crossed the property. And there were issues raised about the adequacy of that and how all that was going to be done. Since then, the town has installed a new sewer main in South Shore Road, as I'm sure most of you know. And our design in the installation includes tying into that new sewer main. The community building that's under construction received a sewer permit from the sewer department and obviously approvals from the water department. We'd be happy to go back to both those departments, or perhaps your staff could, to confirm that the water and the sewer are adequate for the project. Looking at I'm going to just kind of go through the items that I compared sort of in conjunction with the letter that was submitted to the Board of Appeals. The first item is increase in building heights. We had to go back to the original plan and calculate the building heights. As we all know, it can be somewhat convoluted based on the zoning definition. So the architectural plans usually show a dimension from the grade to the peak. But when we calculated from an engineering standpoint, the original building height, we looked at the worst case scenario, and each condition was 30.7 feet. And then under the current plan, I believe this was also discussed last year, reviewing the architectural plans, the average building height is 32.7 feet for the worst case scenario. Also, the bylaw requires that you can't be over 32 feet on one side. And in the worst case scenario, because of the walkout areas in lower terraces that were just shown to you, that's 34 feet on one side. So we would be almost 3 feet over the average around the entire building, and about 4 feet on the one, and 2 feet over on the one side. As mentioned previously, number of parking spaces has slightly changed. If you look at the original plan, you can see the parking fields, how they configured, around the condominium buildings. In that access drive, we had several parallel parking spaces along the access drive. And as Andrew said, pretty much it looks like two separate types of developments. They're separated by access. They're not interconnected. And as mentioned before, under this scenario, we had 3 access points. And you can see how the circulation works on that plan, as opposed to what's proposed, which we feel is a much better design with the one main access and circulation around the middle of the property, along with having these offshoots with the parking areas spread out to serve each condominium building. So we went from a total of 266 spaces to 299 spaces. As was mentioned, 10 of the spaces were land banks, so the net is 289 spaces. So it's about an overall 9% increase in the number of parking spaces from the original plan to this plan. And then with the reduction in the number of bedrooms, in that table that Andrew had previously, indicated that the ratio for parking per bedroom, 0.68 spaces per bedroom. Under the current plans, 1.06 spaces per bedroom. The roadway and traffic circulation, I think, was already touched on. One thing to note is that we took a look at the total length of the roadways. Under the original proposal, it was about 2,925 feet. And under the current proposal, it's about 2,350 feet, about 20% less. Again, because of the configuration and the offshoots for the parking fields, makes a big difference for that. Open space was also touched upon, but if you do a side-by-side comparison, obviously it's a lot different and more cohesive on the current plan. Under the older plan, we did have a playing field, dog run, community gardens, the sewer easement that cut across the site was also used as an open space corridor that was landscaped. There was bocce courts and pool garden and some small parks within the condominium section of the development. under the proposed, again, it's more cohesive, and there's a 25-foot vegetated buffer around the perimeter of the site, whereas before there was only a 10-foot vegetated buffer around the perimeter. And as also mentioned, the total impervious, semi-impervious areas have been slightly decreased under this proposed design. And I think that's it for.
Elisa has a question for you.
Hi, just a couple of quick ones. Where this subject came up before during our last meetings, can you specify what's the trash management program and where are there going to be dumpsters? Are there cans? Are there enclosed spaces? And show me where they are on the plan.
I can't show that. They are on the final landscaping plan, which we did address that because that was one of the comments that you had come up with. So,
Sorry, what's the answer?
yeah, it's not the final landscaping plan.
Does
unless
Andrew,
we can pull it
do you
up
know
here,
where
but-
those are going to
Yeah,
go?
there are each one of the parking zones, there's designated trash pickup area at each one of those parking spaces.
Is it on the plan?
I believe these are these X's that are right here.
Maybe we should label them.
I believe they are on the, like Don said, on the final landscape plan that I don't have.
So you're telling me that these two trash things are going to service both of these buildings? That's it? That's all they get?
I believe there's additional ones located around. Let me look it up.
All right, you don't have to answer now.
Yep.
My next question is, this community building or clubhouse, I don't know what you want to call it, but when you initially applied for this project overall, how many square feet was it then? And how many square feet is it now?
There wasn't a building proposed initially. What was proposed was like a service barn.
Maintenance barn.
That's
yeah.
not included in the current plan.
Is there a community building now? What's,
There's a community building proposed now, yes.
Yeah.
okay, when that was first applied for, when that showed up on a plan during the many iterations, what was the square footage of that?
I think what you might be asking is we put a limit of the square footage on that as part of our first decision, and then it came back much larger. And I
Well,
don't
I'm-
remember what the difference was, because they didn't have one before. It was
Yeah,
a
that's
maintenance
why
barn.
Well, right now, I
It's
mean,
evolved,
I didn't
so-
look at that. That's certainly something we go back and look at, but all we're doing right now is making a comparison of that original plan in the current plan.
Okay, so there was no community building at first,
No.
right?
I don't believe so.
And now there's a
one would-
community
And then
building.
through the process, I think it was added.
And how many square feet is that community building right now? All, just ground cover, we'll say.
Andrew probably has better access to that than I do right
Andrew,
now.
do you know what the square footage
I
is?
don't have it in front of me, but I'll look it up.
And then, and how, I want to know the footprint, and I'd like to know how many stories, and then I'd like to know the total square
Well, there's a
footage.
basement too.
Is there a full basement? And then I would just want to know, you know what I want to know.
So this is a great example, I think, of where there was something that we, as a board, if I remember correctly, felt strongly about.
Right.
Right? Like, this is much larger than the other, the other community buildings in similar neighborhoods. So given that this is now a that the Superior Court said that the project change was a substantial change. George, can you weigh in on this? Are we able to now resurrect our concerns about that community building? Because when it did increase, and I think, because it was a point of contention that we talked about a bunch, and I believe it increased from the original decision, right, or whatever, when we had the first time we had it, the community building come before us, and then what we were given to review last year, it grew even more. So is this, in this scope of this plan being determined, the change to be substantial, is this something that we can?
This will help. Let's go back to that initial plan, the very first plan. If you don't mind, Andrew, or I don't know who's running this, but let's go back to the very first where there was only,
The maintenance
several,
barn.
this one. Will you show us where the maintenance, it was called the
It's in the
maintenance
back
barn.
corner there,
Will you
upper
circle
left.
it?
Yeah.
Okay.
No, no, sorry. It's
That's not
No.
it.
in
That's
the
a
in
house?
south side, in the middle of the site. Yeah, there it is.
Okay.
Okay.
What's that one back
That's a
there?
house up there?
That's a house, yeah.
Oh,
Oh, okay.
And then let's go to the current proposed plan, please.
with no frontage?
And then let's circle that, okay. Okay, thank you.
Hey, Billy, are the architectural plans in this packet? I know we looked at them last year, but I'm just
I don't
curious.
believe they were submitted as, I'm not sure, were they submitted?
Yeah, well, the architectural plans haven't changed since the last
I
summer. when
know,
we
yeah,
looked
I
at
don't,
them.
I don't have
Yeah.
those saved, so maybe
Yeah.
somebody can re-email them.
But
'Cause I-
Okay,
I can do
Madam
that.
Chair, you know, can we get these peer reviewed? I don't know, I mean, this is, I know we're the ultimate approval, disapproval, but I've said this before, like, we don't know how many trash containers there should be there. I mean,
yeah, I think,
we usually vote on encroachments, and
yeah,
I think if we got the planning board and the HDC to review these,
so,
we'd be better off.
right, right, but I think Elise is making good points,
No,
right? Right,
I'm
like,
not-
these are things that need to be looked at. I know I'm gonna catch flack for this, but I'm looking at the clock, it's 3 o'clock.
Susan, though, I
Yep.
wanted to just interject real quick on that.
Yep,
Yes, you want to make sure that you get all the comments on this that you would have had on the original application. So
Okay.
you're sitting in the shoes of various local boards, but you want to get all their commentary on this plan change. You want to consider that, department heads, all of that, and then peer review as you deem that necessary as you go forward. And one thing that's very important that I wanted to clarify for you, the plan review you did last year is not connected with this, what's before you now. What you were reviewing before was conformance as though the project was still going forward pursuant to the HAC order, and that was in the process of the applicant applying for a building permit. That all changed when the Superior Court in the subsequent proceedings said that the HAC erred many years ago, not sending this back to you in the first instance. So you don't want to confuse the review that you did last year in a different procedural posture than the review that you're doing now. And things like building type, size of buildings, location, all of that is specifically within your jurisdiction on this project change, and it is specified in the remand order. So I just want to make sure you know the context that you're ruling on this. It's as though you're looking at the application in the first instance
okay,
in the context of the project change.
okay. Okay, so what I was gonna say was, so, do we have, Don, do you have, how much more do you have to present, do you think?
I'm done. yeah.
Okay. It's 3 o'clock. We have, we only have this room for 1 more hour. I think we should move on to the audience at this point. So I would ask Attorney Durensis. Okay. If we can do a 5-minute bathroom break, but then I don't want, people are going to say they didn't have a time to do their speak. We also have the 2 remand hearings for Ward and Quick that need to be done today as well in 1 hour. No, we have 4, I thought. 4 o'clock or 4:30?
Technically, Charles just texted me, we could go till 4:30.
Okay, so an hour and a half. All right, still not that much. Was the bathroom break for Durensis? He's right there. So let's just keep going. Unless anyone on the board needs a bathroom break. Yeah, go for it. No. Okay, so if the board has no further questions of the applicant at this time, then we're going to move to the next section of this application, which for now will be audience members and Zoom participants that have a comment. So Attorney DeRensis, you have the floor for your comments on the application. Sure.
May I ask questions of the applicant?
We typically don't engage in a back and forth. You can ask through me to the applicant, but I don't really want to get into a back and forth, but if you have specific question, I mean, this isn't a court of law, so I don't want, it's not like a cross-examination.
One of the points I want to make through the applicant submitted papers, and if you all have read those papers make the case for denial of this permit. And I'd like to ask some questions by which they'd have to make some admissions on the record.
Okay, so what I just for by a show of hands, are there people in the audience who would want to speak on their own volition who are not represented by Attorney DeRensis? Okay, 1, 2, 3, 4, 5, 6. Okay, so at some point, Attorney DeRensis, I'm going to let those 6 people speak as well, right? So it's not just, this isn't just for you. Do you want them to speak first, or you want to go first and then?
While the former witness is still fresh in your mind, could I ask him a few questions and
Yeah,
then
they're
sit
not a
down?
witness. It's just an applicant. It's not a witness. So
He submitted quite a bit of sworn testimony.
and what are you referring to? Which ones?
Mr. Bracken.
No, I mean, what part of the packet?
The applicant submitted,
Oh, Exhibit 10, the pre-filed testimony?
yes.
Okay.
So if I could, I'd ask him a few questions and then,
I don't think we're gonna, at this point, we're not gonna, I don't think that's constructive right now, and not because of the process, but because that's not typically how we,
this isn't a typical thing.
I understand that, but also, this packet is over 1,200 pages. The board needs time to review and absorb all of this, so I don't think, we're not going to cross-examine the applicant's engineer at this point. I don't think it's appropriate. I think what I'd like to hear is your overall presentation about the remand hearing and the review that this board is going to do. And if you have concerns that you would like us to pay attention to while we do our review of everything that was submitted, that would be helpful for things that we should pay attention to, or that you'd like us to pay attention to or look at specifically. And I think then if there are questions specifically for Don Bracken or anyone else, then those could potentially be submitted through staff for us to consider at a future hearing date. I think is the best way to do that at this time.
Well, let me summarize from his testimony what I would have elicited from him, and then go on with, if I could, a more general statement about what we're trying to do here.
Sure.
He has testified, and I'm not going to cite the page numbers at this point, but he testified that hydrologically, the soils at the site are classified as classification A, which is highly permeable soils. He classified them as Eversborough soils, which means that any spill on the site is going to move. And where is it going to move? The groundwater flow is south towards individual residents. There is a well that's 21 feet from this project. The design for stormwater is subsurface infiltration systems to return stormwater to the aquifer. So any spill at this site ends up being drunk by the residents. So if somebody has COVID, for example, and they throw up on the lawn, those germs end up in a drinking well 21 feet away. And what were the protections for the residents? Well, one of the things that Mr. Bracken signed was a representation to DEP dealing with how they were going to deal with stormwater, in which he says, quote, tree clearing and topsoil removal shall be kept at a minimum. Similarly, in the construction plan for the work to be done at the site, the plan specifies minimizing disturbance to existing trees and shrubs. These were filed with DEP, they were filed with HAC, they're part of the pretrial testimony. So one of the things we want to do is to ask for a site visit by this board to the site so that you can judge for yourselves the credibility of what you just heard from that particular witness. For purposes of the record, I'm going to treat that as an offer of proof of what would have happened during cross-examination. It's all part of the pre-filed testimony, already in the record in this case. So the reason that we're here is because a Superior Court judge ordered a remand back to the Board of Appeals. The developers of Surfside Crossing opposed it. The Housing Appeals Committee opposed such a remand. The Superior Court blew away those arguments in a very strong decision. That decision is in your packet. Our position is today, as it has been all the way along, that the citizens of Nantucket are entitled to be safe, to have developments that work not only for the surrounding residents, but for the future occupants of this development. And we will prove, and the record already submitted by the developer proves, this project has inferior safety features. So we start with the assumption that all people should be treated equally, regardless of their economic status. Why should some people have to live in housing that's not safe? And that's what's being proposed for you to approve. Let me say a word about what the court asked us to do. Because that's been a subject of considerable discussion. The court expressly found that the number, location, and size of all the buildings on the site have changed in the altered proposal as a result of the complete elimination of the single-family building type. This altered configuration results in changes to roadways and traffic circulation, a reduction in open space areas with a reallocation of the majority of open space from private to community use, conversion of the majority of parking from a distributed pattern throughout the site in semi-pervious driveways of single-family homes to a collected pattern in 12 impervious parking lots, largely located on the periphery of the development. And I might add as a footnote here, so that headlights shine into the homes of the residents who are living south of this project. Going back to the court judge decision, those changes in the type, number, size, height, and location of buildings, together with changes in parking spaces and configuration, open space design changes, and changes in roadways and traffic circulation within the site cumulatively amount to a totally new or different proposal. The altered proposal, in effect, amounts to a wholly new project requiring remand for the board to consider in public hearings the impact of the number and location of the multifamily buildings on legitimate matters of local concern. And that is the charge before you. And incidentally, the Superior Court is superior to the Housing Appeals Committee. We are proposing a series of witnesses. We have submitted, and you have before you, pretrial testimony from 6 witnesses that were part of the proceedings before the Housing Appeals Committee. That testimony, the developer chose not to cross-examine and chose not to submit any rebuttal papers. And therefore, the way the system works, unrebutted testimony is to be taken as truth. So there's the testimony of Diane Coombs, who's testified. This was in 2022 when these hearings were being held. I comment here concerning the non-compliance of the current version of the proposed Surfside Crossing development project with the Historic District Commission Act, with the Nantucket Historic District Commission bylaw and the project's harmful impact on its residential neighbors and abutters. The noncompliance cannot be resolved without significant alterations to the size, density, and configuration of the proposed project. Again, at the hearings at the state level, we had the testimony of witness David Franzuto, the former emergency management director for the town of Nantucket.
Attorney Durensis, are these were included in the submission that you made to the board, right?
They're included, yes, but
Okay.
that submission was an inch thick, and it's on page
Okay.
1100 of a book that's like
Right.
almost 2,000.
So
I'm trying to bring those witnesses to your attention.
I believe we heard from some, I don't want to cut you short. I also don't want to not hear from the other people in the audience, and I still have to get to two other things. So
Oh, yes.
can I maybe give you, if I give you 10 more minutes, can you get through your presentation in that time? I'm also promising other members of the audience equal time. And this isn't, I want to be clear, this isn't our last hearing on this. I want Attorney Durensis to be able to make his presentation. I just don't want to, if you're referencing specific things that are in the packet that you submitted,
That are in the record that I want to have before this board so that you're thinking about it. Because you're now sitting as the HDC.
Yeah.
And you're hearing from a former, now retired, but back in 2022, Diane Coombs, that this project is no good under the HDC Act. It needs to be reworked. That's something that needs to be in the mix with you. Let me, if I could suspend this piece and give you one diversion, which is to go for a minute to traffic. We have some pictures we want to show you today and mark as exhibits.
Can you just go to the mic and just, yeah, it's okay.
You have the small ones.
I do, I'll give them the small one. So one of the things that.
Just say your name.
So this,
Can you just say your name so everyone knows who you are?
I'm sorry.
That's okay.
Linda Durensis, the other half.
Yeah.
So in the traffic study, they taught, in everything that they also said in their presentation is also in the stack of your holiday reading that you got to do. And their traffic study is from 2016 that they don't mention. But if any of you were on Surfside Road this summer and had the great pleasure, you couldn't even see the intersection because it's so backed up. And to say that the traffic is going to get better when you put 150 new homes in right at the intersection, we have more pictures and we will submit them, and we have them in an 8x4 since you don't have it. But the traffic went on and on. You couldn't even see the boulevard was backed up. You couldn't even see to the end of Surfside Road. And for them to stand here and tell you the traffic isn't going to affect, there's no effect, don't worry about it, is outrageous. I mean, at least let's have a dialogue that is honest and back and forth. Everybody is for affordable housing. We want safe, affordable housing. If you talk to anyone this summer, they're like, it took me 45 minutes to get to work. People, you can't live like that. So when they talk about the traffic study from 2016 and that it's getting better by 1% every year, that's outrageous. I've lived here for over 30 years, and I can tell you from my house, it has gotten worse every summer, and that's without 150 more homes in a very short thing. Jamie and Josh, when they said they came and they were like, when we were going through this review, we came up with this better idea. You three sat in the hearings, which I sat in the audience. There were paper dumps for you. You know, things were missing in the file, and suddenly they want us to believe these are two professional developers. There's no question about that, when they were doing the review, they came up with a better idea, not the homes that you approved. You said, you know, it's too big, 60 homes, that they suddenly came up with the idea, condos are the way to go. They could have said that at day one. You know how many plans they came up with as you sat through years of hearings. And it would have been easy for them to just come out in the very beginning and say, hey, this is what we want. We're gonna kill the traffic. Let's have an honest discussion this time. And let's talk about how awful the traffic is. Whether it's also, there's only one entrance this time. Do you want to would you put your child, you're going to ask a school teacher to put their child in a development that has one entrance so they can get in? This is what the traffic looks like coming from the beach. These people are coming to the beach and going to work. They're not trying to get out of a 150 condo development during a fire. So let's be realistic. Their new plans has one entrance. It's all scrub brush. Remember the fire in Dionis a couple years ago? Do you remember the Veranda House fire? By the grace of God, no one died. These buildings are 19 Veranda House size buildings. These developers could have come in the very beginning and said, hey, this is the best way for us to make money. Let's have an honest discussion. Let's not pretend that there's not going to be any bigger traffic because we're putting 150 homes there. Their expert, when they testified last time, said it's an F intersection. F, you can't get worse than F. You know, you can. These are the traffic is awful. It affects the quality of life of everyone. People who live around it, people who live in it. One entrance and a fire. If you were here that day when the Veranda House, you could smell it in Surfside. And that was one building. Firefighters were going in without any equipment, and that's what they want to put us at risk. Let's have an honest discussion and quit pretending that this is being done for the good of the community. Everything's going to be great. It's going to be worse. You also have the option, as a judge at Superior Court said, which I also sat through, you have the option to say no. You know, there is that option. When we were in court every day, guess what? There was no one representing you. The judge even said, who's representing the ZBA? And it was like, you weren't there. We were there. We have been fighting this fight. It's time to have an honest discussion, not pretend that two developers who have done this for decades suddenly got a light bulb moment and said, condos are the way to go. You know, they could have said that on day one and not wasted years of your life. You guys put in tremendous hours. All those dumps, you know, let's have an honest discussion this time. Let's hold people accountable. And if they can't be accountable, then let's say the word that no 2-year-old wants to hear, no.
Okay, thank you. Okay, so,
Let me just finish up with traffic.
sure.
The way,
I mean, I think we've talked about traffic up here. I think we're probably, we are.
We're not gonna only talk about this tonight.
No, we're not
There'll be
only,
many
we're,
opportunities
this
to talk
is,
about
all that's happening right now is just, I think, giving us an overview of the issues that are concerned. I know, so I really want to hear from some of the other community members as well, so.
I'll just finish up traffic, then I'll sit down.
Okay.
But I have like 20 of these pieces of a puzzle on the traffic stuff, the
And
defense.
hold on, and I just want to say, Attorney Durensis, this is not going to be your only opportunity to speak. Like, I know you guys are going to be here through the process and commenting on as we move through it. So I just want to make sure you understand that, like, this is not your one shot. This is just your first of, I'm sure, many opportunities to participate in the process.
So the way that the developer expert says that this is a perfectly fine intersection is by a couple of what I call sleight of hands. The first is they say, we need to average the counts for the entire year. And therefore, you have to look at the traffic in February and January at this intersection, average it all out, and that knocks down what we're seeing for 3 or 4 months of the year to a number that's, they say, is a D intersection as opposed to an F intersection. We all know that Nantucket is a seasonal community. We all know that there are aspects of life on Nantucket that's different from these mainland methods of looking at things. If you were in downtown Boston and you're looking at traffic counts, averaging it year-round may make sense. But in a seasonal community, in their traffic study, they say a queue of 8 cars is an F intersection. There have been almost every day more than 8 cars. Yet their reports say everything is fine because we're averaging it to include February. They also have based everything on the Richmond traffic analysis from August of 2016, which is what they say in the report 8 years ago. And in 8 years from 2016 to now, there's been a lot of changes.
Madam Chair.
Yes.
Excuse me, with all due respect, and I really do mean that, you're reiterating things that have already been said. We totally get the traffic point. Everybody here lives here year-round. We just went through the summer. With no disrespect to you, I want to hear from other people. I feel like you've had plenty of time. You've had a half an hour. And I think it would be gracious to let other people speak. Thank you.
Okay. So I see Emily Molden. Could you just come to the microphone and identify yourself, and then
Thank you, Madam Chair. Good afternoon. For the record, I'm Emily Molden, the Executive Director of the Nantucket Land and Water Council. As I'm sure you all know, we were significantly engaged and opposed to the project when it was before this board back in 2018 and 19. And we're also one of the parties that were involved in the appeal of the HAC's decision. I want to thank all of you for re-engaging on this matter today. I think in spite of what has happened between then and now, we certainly still have significant concerns about the impacts of this project in the context of the new plans that have been proposed. In 2018, 2019, we hired a consultant, Tom Houston, from Professional Services Corporation to provide a peer review of the plans, and we have re-engaged with Tom Houston to provide a comprehensive peer review of all the technical aspects of the plans. I expect that review to be forthcoming, and I look forward to providing it to the board that hopefully can be considered during your deliberations going forward. We also strongly support and encourage the board, as you've discussed, to engage with your own consultants and additional peer reviewers to support your review of the project. I think it's very important that the plans that are before you now be reviewed in the context of our island today. I'm going to keep my comments brief and leave it at that for this afternoon, but I look forward to providing additional comments and our review to you in the coming weeks. Thank you very much.
Okay, thank you. Is there anyone else in the audience who wish to speak on this matter? Just if you can identify yourself for the record.
My name is Mindy Levin, and I live in the neighborhood. And even though this project is, I think, 23 or 6 bedrooms less, it still should be considered whether it's appropriate for the island today. And some of these things need to be considered. And you can, even if it is less traffic, it's still over 1,000 trips a day and 1 exit. And so I urge you to take it into consideration for today and whether or not it's still appropriate. Not that it's 25 rooms better, but is it appropriate for the neighborhood and for the community? Thank you.
Thank you. Is there anyone else who would like to get up and speak? Just, I guess, you, sir, first, just identify yourself, and then we'll go over to you, sir.
My name is Kramer Mumford. I'm an island native. I mean, if you guys can't see that housing is needed, I mean, regardless of the size of the picture, housing is needed out here. It seems like this town has a quick way to deny anything. Housing's needed. It's plain and simple. I mean, the plan got lessened to try to get approved. I mean, look at how many people applied for the Wiggles Way and all that. So many people, they had to cut it off. There's so many people out here that need housing that this should just, I don't get why there's always a problem when something comes up that it's obviously needed. Oh, wait, look at this. 1 exit, add another entrance and exit. Housing is just, it's simple. To just do the math. We need housing. So.
Thank you. And you, sir?
My name is Jack Weinhold with my wife and Mary Beth Splain and our daughter. We live at 11R South Shore Road. I'm 84, my wife is 91. She uses a walker, does not drive, but is assigned a handicap parking tag. Our property abuts the southern boundary of the proposed Sherburne Common project, Surfside Crossing project. The northeast corner of our house is 21 feet from the boundary. Our only water supply, a well between our house and the southern boundary of the project, has served us without problem for 32 years. Due to groundwater flow, any contamination on or release by the project will flow into our property, contaminating our well. Being as close to the boundary as we are, our property is especially endangered from a fire in the proposed project site. Since South Shore Road dead ends in the south, our only egress in case of a fire would be north into the traffic jam that would occur on South Shore Road. Because of the design and the size of the proposed project, I understand the fire chief believes it presents firefighting access problems with serious public safety concerns for not only our property, but for the surrounding neighborhood. I'm very concerned with the prospect of increased night lighting and the noise and traffic congestion of 281 cars from the project on our property and lives. I understand the developer has requested a waiver of all visual screen requirements for all parking on the development. I'm concerned that the proposed development, with its more than 300 vehicles and congestion issues, will dramatically impede access to our home in case of fire or health emergency. This concern is heightened by our age and health and extends to our neighbors along the length of South Shore Road, and especially the residents of Sherburne Commons. Changing the slightly here, something that's so important to me. 200 years ago, a good drink of water came from the nearest rain barrel. Today, health officials say that it would be too dangerous for our health. Island winds bring us the rain containing smoke particles from every industry west of here and the exhaust of millions of vehicle tailpipes. Unfortunately, roofs, streets, sidewalks, and driveways are all impervious surfaces, funneling stormwater into concentrated streams, endangering our only aquifer. Surfside crossing water will overwhelm the proposed filtering process, sending the toxic water into buried storm tech chambers, that's a name of a company, sitting on top of our drinking water. That method of handling stormwater runoff predates what we know now about PFAS and microscopic contamination of water supplies. That's a big deal, a really big deal, and it breaks federal and state law to do it the way it's proposed, handling stormwater. The state regulations for stormwater runoff are years behind the science and without any understanding of the unique requirements of an island sitting on top of its water supply. Unless we begin to properly treat stormwater runoff in all island developments, and especially in large-scale developments such as Surfside Crossing, we are on the verge of losing our drinking water aquifer and then deciding where to build the seawater desalination plant. This is a time bomb with a fuse that shortens every day because of increasing storm severity caused by global warming. The devil is in the details. There are solutions. I urge you, for the sake of our children and everyone who expects to continue living here, to require Surfside Crossing to use the correct storm water treatment process and save our aquifer. Thank you.
Thank you. Is there anyone else in the audience who wanted to speak on this? Okay, so maybe just come down to the microphone and you can kind of line up and then I can see how many we have. I think I probably can take public comment for, I think, 5 more minutes to ensure that we have time to do the next 2. Yeah, okay.
Madam Chair, Kathy Ward, I just have a question about the traffic flow. When they're studying this, are they taking into consideration the possibility of the movement of our island home out there, which is going to create another traffic situation as well?
Okay, good point. Thank you. Sir, if you can just identify yourself for the...
Yeah, I will.
Sure, okay.
My name is Chris Meredith. My wife Linda and I live at 1 Wero Lane, and our property directly abuts on 2 sides, the site of the 156 unit development proposed by the applicant. Our house also is about 40 feet from the southern boundary, and our backyard and gardens are 10 feet off the southern boundary of the project site. It's our only water supply is also right on the property line. Our well is active and it has never been any problem with any quantity of water. It gives us all our drinking water. The flow of the groundwater on the property is from the north to the south, which is from the development area directly into our backyard. So we know that because our property sits and abuts the property in this particular area, the possibility of pollution and the permeability of the sandy soils, any contamination released from the project site into the groundwater would likely flow into our property and completely contaminate our wells. And there's something, I need to give you copy. I'd like to give you copies of these. This is the new, there are 2 new wells that have been put on the property over the last 5 years. And those are now the existing wells that flow that abut basic property and all of their.
Thank you.
As you can see from the, I tried to outline the, all of the drainage systems and the parking lots. And I was under the assumption that you're not allowed to build parking lots on top of wells. And this is really close to my well. I think 80% of the parking lot is covering my 100-foot protection zone. So we're kind of a little bit disappointed by all of this. There's other things that obviously are bothering us, but this one is definitely the most important to my wife and I, is our health and our ability to drink good water, which we've had for over 30 years. We've been living on this island for a long time. And this is going to jeopardize our home and our life here. So I'd like you just to keep all of that in mind when you're thinking about this, because it's not just about the pretty picture that they've drawn of just that area that they think is so pretty. It's about the people that live around it and how it impacts them. Thank you.
Thank you. Yeah, sure. Mr. Meredith? Yeah, it's from Bracken.
Bracken and nothing was added.
No, I basically took I did the work on it, yeah.
The part with
I took
the
their
wells.
original drawings, put them to scale, imported the original
Okay,
drawings
that's-
from my surveyor who had drawn the water well distribution areas, and then I just superimposed it over, and I highlighted the areas that they have on their map of their drainage fields and parking lots, and basically just took the 2 pictures and married them together, because
Okay.
I don't have the money to hire
Yeah.
people that.
No, I just
so-
wanted clarification. I
Okay.
didn't know if Don
Okay.
Bracken produced all.
That's a good
Yeah.
question. Yeah.
No,
Okay.
I use their existing drawings to try to tell a story of what's going on there, because nobody else is telling that one.
Thank you.
Thank you.
Good afternoon.
Hi.
I'm Madeline Callahan. I live in Surfside. I want to thank all of you. This is 7 years we've been having these meetings. And as time has gone on, and the evolution of these meetings has resulted in this, we're all very incredibly impacted. And I think that at this stage in the game, our biggest problem is having to abide by the 40B, which should never be allowed on an island. So skipping that, we can't really sue the state or the federal government, but I think this has been thrown in our laps. And the simple fact of the matter is that it took me 27 minutes to get from the boulevard to the intersection and to be able to get into the queue for my turn to make a right, which is the easiest way out. So everyone here is impacted. This situation is so dire to not just Surfside, but the whole island. Anyone who ever wants to go to the beach again on the South Shore, I would love to implore that these developers go away, but in all sensibility, I know, in all sensibility, this is so large, and luckily, 7 years later, or 7 years, 8 years later, the impact is so much greater on all of us that I think we all have to step back and do whatever we can to prevent this and to prevent the size and these poor neighbors. And thank you for your time. You're unbelievable to listen to all of this.
Thank you. Does anyone else have any comments before? One more, sure.
My name's Kramer Mumford.
Your name, sorry, just say your name again.
Kramer Mumford.
Kramer Mumford.
Like, I don't understand where people think that the people that are already on this island don't need housing. There's already all these cars here. Majority of the people that are already here also need housing. It's not like we're gonna have, I mean, sure, maybe, but the likelihood that an influx of however many drastic number of cars you think are actually gonna come to the island, there's such a need that's already here that the traffic coming from look at the Habitat for Humanity. Those are on-island people that got the houses. Everybody here needs housing. I can name numerous families here now need housing. I mean, I get that there's other things coming up. Monday, the thing goes live, but the need for housing here now is so great that I think the influx of cars coming and the traffic here is already so bad. I mean, what do we expect this to be, in a retirement island? No families here. Everybody's got to be single family. Families are here. Families need to be here to have the island grow. Without that, I mean, what are we going to just cut off the working force? Retirement, got to be retired to live here. I mean, that's what it's going to. Families are here that need the housing. Let's just look at that. This influx of cars, I doubt it's going to happen. People that are here now need the housing. Simple.
Thank you. Okay. Is there anyone on Zoom to speak? Okay. Attorney Haverty, do you have something?
Madam Chair, just quickly, if I could request on behalf of Bracken Engineering that plan that was just submitted into the record, if you could black out the Bracken.
Yeah, I made a note
block
too.
Because it's not a plan that they prepared.
Right,
you know,
right.
on the whole.
And as the speaker said, he did it of his own and superimposed to tell a story, but
Right,
certainly.
understood.
What? Yeah, no, I agree. We can exit out, and it's for illustrative purposes only, understanding that, and I think it was a good question that Jim asked to clarify that. Yeah, yep, go ahead, sorry, no, go ahead.
Before we move on, which it looks like we're gonna be doing in a few minutes, I'd like to circle back to, I would like to circle back to their initial opening statement, Mr. Durensis, saying that 3 board members are in conflict. I'd like to go back to that, and I'd like to know who are the people that you're saying are in conflict that you do not want to serve on this application, and why?
Sure. I filed a complaint.
And just, Megan, can you just say your
Sure,
name?
Megan Perry. I filed a complaint with ethics based on the regulatory agreement that was before this board, and you were all advised to sign by town council almost a year ago. And in that, on page 6, section D, it said that there was no pending litigation according to Surfside Crossing, and the board signed off on that as well in the acknowledgement agreement. I think we were all well aware that there were 2 lawsuits at that time currently going on, and there's been almost a year to correct that, and that hasn't been corrected. So that was an incorrect document to sign.
So who are the people?
So the 3 members who signed that document.
Which are who?
That would be the chair, that was yourself, and I believe John Brasher.
Okay, thank you.
Was the misinterpretation that there was no ongoing litigation with our board? Was that what you were?
The terms of the regulatory agreement state, and we, with the,
The regulatory agreement's in your packet. It's on page 6, section D, and then there was also an acknowledgement agreement that this board signed, and you had 2 attorneys on this board that signed it, and also town council had reviewed it and asked you to sign it.
Are you sure you want to do that, or do you want to think it through a little bit more?
I think it's already filed. It's too, that ship
Do
has
you want to
sailed.
rescind the filing, or do you want to think it through a little bit more? Think about it.
I think
She'll take that under advisement.
what we signed on page 117 of the packet is we're signing an acknowledgement that at the developer's request, that it satisfies the requirements of the comprehensive permit as defined therein, and that was reviewed by town council. I think we'll take it under advisement. I think we'll let the ethics commission or
Yeah,
whoever you
let 'em
filed
give me,
it
this is the
with
first
look
I'm
at it.
hearing of it. I wasn't aware of it. And
so I think-
look forward to them calling me and, reviewing if I have a conflict.
Great, thank you.
And I will be happy to rescind if I think there's a conflict.
I did give Billy a copy for the record.
Okay.
So you do
So,
have it if you
yeah,
want to
so I
take a
think-
glance at it.
I think that'll,
You just got it today. Okay, that's why I haven't seen it yet. I just
Okay.
got it today.
Yes, it's a confidential document unless the person who files the complaint chooses to provide it. It's for whistleblowers' protection.
Well,
Okay,
thank you for
well,
sharing
is
it,
it
I
ever
guess.
to be, when was it
So-
supposed to be brought to our attention
No.
today?
Well, no, but I guess I think they were making it public so that, to give us the opportunity to recuse if we felt that we had a conflict. I think that the Ethics Commission, I think what they will do is reach out to individual members
Yeah.
or anyone who has a complaint against them, and
Okay.
then we'll move through that process.
Got it.
Okay.
If I could,
Yep. And then we have to move on.
I just want to remind you that the law that's alleged to be violated is a criminal law that subjects a person to 5 years in state prison or a $10,000 fine.
Duly noted, but
And
literally
that's
we,
why I asked you to stop this. You could step aside, you could have adjourned this thing until you got a ruling from the State Ethics Commission, but you decided to go forward
Well, if-
and to participate.
I think.
A choice that you made.
Okay, I understand that. I also think that if we did that and adjourned until the State Ethics Commission made a determination, I've not had to go through that process, but I've heard it's lengthy. Maybe I will find out shortly. But the close of the public hearing is January 31st, 2025. We do not have much time, and all of the concerns that you guys have brought up are relevant. If myself, John Brescher, and Elisa are off, you don't have enough members. You're going to have
Susan,
one, all right,
Susan,
4. Yes,
Susan,
Jim.
I
Yes.
just want to interject. I recommend against engaging in that dialogue.
Okay, so let's move on.
This is a matter of public record. The regulatory agreement speaks for itself. The signature page speaks for itself. The provision that Megan cited speaks for itself. Apparently, the complaint is now a public record because she produced it during these proceedings and was handed to Billy. We'll look at that. You did have, let's be very clear. You did have an opinion, a lengthy opinion from Vicky Marsh from our office opining on it. That can be treated as a public record as well. And we're happy to assist on any issues in that regard going forward. In my opinion, the conflict of interest claim does not have merit, but that is not for me to make that determination. If the State Ethics Commission investigates it, I'm sure they'll have a conclusion, but it's not fruitful to go back and forth on a dialogue on this. Let the Ethics Commission deal with the complaint. The extent we're asked for an opinion, we'll provide it. The opinion from Vicky Marsh to you that you read and you were consulted on before you signed the agreement is also a matter of public record. So I recommend you just shelve that. You've taken the objections under advisement and you just shelve the discussion on that for now, it is very unfruitful to be talking about felony convictions on something before the actual felony gets proven. So murder
George, I
has a
just
very
wanted to
big
hear it out
conviction
loud,
rate
just-
too.
Sorry, George, sorry to interrupt, but I want to say that I didn't look to really engage. I just wanted information that was brought up earlier on and not avoid that discussion and definition of what's
Right.
being.
I appreciate that. I just wanted to clarify that throwing out words like it's a felony and you'll be sent to jail and things like that. Well, that's all well and good if a felony is proven and somebody is convicted, but it's really not helpful to your proceedings for somebody to be making those types of accusations against you. The Ethics Commission will see that complaint through to a conclusion. And that really is the end of that discussion for now.
Okay, thank you, George.
Madam Chair, could I, not related to this, something related to the regulatory agreement? Just a quick.
No, I think we're gonna move on. I think we can talk about the regulatory agreement after we've actually had a chance to I haven't read it in a year. I'd like to read the complaint, let's move on. I think
I just had a question about the recording of it and its validity, now that this has changed. So
Let's
it's
ask-
of record, and I just didn't.
We have to move on. So that'll be a great question for next time.
Can I end on a positive note and say that it's not against housing at all, it's just too dense.
Okay,
That's all.
thank you. Mindy Levin, right? Right.
Yes, Mindy
Okay.
Levin saying,
Okay, thank
it's
you.
not against housing, it's just too dense of a project.
Okay. Attorney Haverty, did you have anything else? You're standing there, so.
I'm just
And
waiting
then I want to
to,
continue.
for the rescheduled hearing.
Yes,
for-
okay.
For the next
So
continuance.
let's continue this until, let me look. Let's talk about continuing this discussion, and everyone will have a chance to read through these 1,200 plus pages. And the other, we had a few emails that came in after the deadline, which will be, I'm sure, included in the packet next time. And you can all print them out from your computers. Billy gave them to us. I think we were, so let's continue this. What were we talking, when are we thinking? We're talking about,
I think you all need some time to review this information. So the next regular meeting is October 17th. We could set up a
wait,
different.
sorry, what did you, yeah, October 7th.
October 17th. Actually, the next regular meeting is next
Yeah,
Thursday,
that's
but
not
we
gonna
can't
work.
flip this on there.
So what do we have on October already? Three
October
other,
17th, did you
October
say?
17th. We might have,
It's getting lengthier because 90% of the agenda is getting continued for next Thursday.
And
Okay,
Susan,
Yep.
I just need to interject, sorry, respectfully. I have a conflict on the 17th that I cannot be with you, and I would
Okay.
recommend that whatever you pick, I be available for.
okay.
Susan, one
let's
other
do
thing
this-
too, one
Yep.
other thing that I would recommend the board in the meantime, with the lengthy submission that you have between now and the next hearing session, for whenever you schedule that for, I would recommend that the board members start to think about, first of all, solicit the departmental review and comments from town boards and department heads and, all of that. Try to get those comments going and to the board, and that the board members also start to think about technical issues that they want to have addressed through peer review, because it would be great to have, that underway, or at least be able to set the process going on that at the time of your next hearing session, so you don't run out of time.
Okay,
Madam Chair, can I have a request on that related to that?
yeah, what,
I don't know what the process is for getting peer review involved. Is it just emailing people? But can we get that of record so there's no dispute about when someone receives it, or, if the fire chief got the request or not? Some way.
We should start all that process now, right?
Yeah, I mean, I need to obviously talk to my department head. This is the first time I've
Yeah.
ever dealt with a scenario
I
like
think it
this.
would be helpful. for
So
me.
confirmation of receipt of the request.
Yeah, so we know when they got it, we know how long they've
Yep,
had it.
okay, I think that's a good idea.
Yeah, and just to add to that, on Jim's comment, your typical process, that it's actually required that the notice go out. And I can help Billy formulate that about, what you would have sent if it was the normal application from the beginning. It's typically, from the zoning administrator, and it will be addressed to numerous department heads and town committees, and it will, provide the application information and solicit the comments back. So I think that's a very good idea to have that documented about when that went out, and just use it as kind of a checklist about when you get those comments back.
And do we need to, can that happen through staff between meetings, or do we have to decide at a? What?
No,
Yes?
absolutely. Billy should send that out to the department heads and the department's town committees, all of that. In the meantime, the peer review selection would probably be better if you just bring it back for a discussion with the full board at your next hearing session.
Okay. Okay. So perhaps we should, I know George can't be available on the 17th, but perhaps we should continue to the 17th, and then can we reschedule?
Yeah, I think that's the smartest maneuver here, is we'll continue to the 17th, and if we're able to have some sort of meaningful discussion on the 17th, then we can have it go forward, or we can continue to another date certain within a reasonable time from the 17th.
Okay. All right, so would someone make the motion to continue 2524 Surfside Crossing LLC to the regularly scheduled October 17th Board of Appeals meeting?
I'll make that motion.
So Lisa makes the motion. Can I have a second?
Second.
Lisa seconds.
Is that going to be, that's 1 PM?
I think so, yeah.
Yeah.
Yeah, thank you. All right, so I'll do roll call vote. So an I vote will continue till October 17th at 1 PM. Elisa?
Aye.
Lisa?
Aye.
John Brescher?
Aye.
Jim Mondani?
Aye.
And myself, aye. Is that all five? 1, 2, 3, 4, 5. Okay. Okay, so that continues to October 17th, and that will be the public hearing. So we'll continue to take public comment at that time.
Thank you, Madam Chair, members of the board.
Okay, thank you. Okay, so next to discuss is Kathy Ward's remand hearing, 1124, 9 West Dover Street. And, that decision came in to my email at 7 o'clock last night. And I had meetings this morning, so I did not even get to it till 11 o'clock this morning. And did not have a chance to review it, either one, before this meeting, given all the other stuff that I had going on. So I have not done the review that I would want to do for this, and I'm just saying that because
So can I make a motion to continue that to next week, when our regulars?
till September, to the September 12th?
If George is okay with that date, we could easily go to the 12th, because I already have the meeting set up, so I just need to add the items onto the agenda.
Yeah, I would appreciate that, because I want to give it the time it deserves, and I don't want to I'd like to review it. I'd like to be able to have a conversation about it. If people have questions, people in the, so.
Can I just make a request for that?
Yep.
If you could possibly start with it on that day, if your meeting starts at 1, I have a conflict for 3 PM, but I could, if you had the discussion at 1, I could make it, or if we finish by 3.
I think we should definitely finish by 3, but yeah.
And then I just wanted to give it would be very helpful for me to give a quick overview when you're done with this discussion, to highlight what I did on that latest draft, so that when you review it, you have that answered ahead of time.
Yes, that would be helpful. And then if anybody who did have a chance either last night or this morning to review it that has any specific questions for you, but then.
Yeah, so as kind of an executive overview, I wanted to clarify a couple of things. Number one, I wanted to clarify in your decision more precisely exactly what you're ruling on with all the relevant zoning bylaw definitions, taken from the court decision and also the zoning bylaw. So I set out the decision with sections, starting out with the history of what's before you, and then a summary of the relevant bylaw provisions and definitions, and then the public comment and findings that came as a result of the remand hearing, and then a final section with your analysis and conclusions. And just a couple of things that I wanted to clarify. The board had talked previously about sort of redefining this term short-term rental, to avoid sort of a pejorative sense of that term. I reworked the decision, actually reinserting short-term rental where appropriate. And the reason I did that is some of the comments that you received were specifically referencing short-term rentals versus residential rentals or any other type of rentals. And the other thing that I did, because that last discussion was very useful in terms of hearing from you exactly what your reasoning was behind this. I went back through the case law, and you want to be very careful about redefining terms so that it becomes vague or unclear exactly what you're talking about in light of the case law. So I reinserted that word in certain places where that would be consistent with how the land court talked about it. Sometimes he said short-term rentals, sometimes he said rentals. The Stiller case, which is very important, also talks about short-term rentals. So I was careful with the language that I use, and that's why you'll see that word in various places in the decision, based on that review and analysis. The last couple of issues that I did were, I did mention that things cited in your decision are not necessarily exhaustive, as you had noted last time, Susan. I did think it was worthwhile because both Susan and Jim mentioned specifically Ms. Baltzer. And I went back through the record and reviewed the materials that were submitted by Ms. Baltzer during the public hearing process. And I did add her specifically to the decision in addition to that, that this is not the exclusive amount of presentation that was presented to the board. And then the last thing, Susan, you had specifically mentioned that you found the argument about the Matalone case from Attorney Cohen particularly compelling, and I did elaborate on the board's agreement with that position and the analysis of the Matalone case. So I elaborated on that a little bit more in your decision. So, and then the last caveat that I wanted to give you when you go ahead and read this final decision, which again is not my decision, is as best I can glean from what you're communicating to me, what should be in the decision. I'm trying to put it in a coherent manner. The last thing that I wanted to note to you would be, I recommend you avoid getting into such detail that you're turning this into a legal memorandum, an appellate brief or a memorandum in support of a dispositive motion. You want to keep in mind that even though many of you are attorneys, you do want this to be a decision of a board based on your local review and not, a legal memorandum. So I tried to keep relevant case law in there without overdoing it in terms of any legalese or legal arguments. And then the final thing I think I'd really like to emphasize to you is I would recommend very strongly that if you have further suggested revisions to the decision, because the decisions I've put before you are, in my opinion, consistent with your discussions and the reasoning that you've expressed to me. So I would recommend strongly you think long and hard about further suggested revisions to it. And if you do have further revisions, I would recommend also very strongly that you focus those on your reasoning or rationale in terms of your interpretation of the plain language of your zoning bylaw, because that's where you get deference. So if you have more, or you think what I put in here is inadequate in terms of your rationale, how you're interpreting your bylaw language, that would be helpful if you have revisions in that regard. I hope I captured it for you, but if I didn't, you know, that would be what I recommend you focus on.
Okay, that's helpful.
Makes sense.
Do you have a question, Jim?
Just one, do we have a deadline on this, George?
I wasn't worried about it before, but now I'm getting a little concerned. I will prepare a status report to the court and advise, you know, what the status is, and hopefully that will be acceptable to the court, you know, with the representation to the court that we're fully anticipating a final decision will be reached and issued on the 12th, if that's reasonable.
Yeah.
Okay. Okay, seeing no other questions, we'll continue this till the September 12th meeting. And what is this number? And we can also continue 2024 Christopher Quick, 15 Delaney Road. I think we're the same voting board, right, to the same time, September 12th, 1 p.m. regular meeting. Okay, would someone make that motion? All right, Elisa makes the motion. Can I have a second? Michael seconds. I'll do roll call. Elisa Allen? Aye. Michael O'Mara? John Brescher?
Aye.
Joe Marklinger?
Aye.
And myself, aye. Okay, so we will pick these two back up at the beginning of the meeting on September 12th at 1 o'clock. Okay, thank you everyone for your time today. I appreciate it.
Move for.
Oh, yeah, we got to,
adjournment.
oh, yeah. Yeah, I just want to see if there's anything else
Second.
on here. I did both at the same time. Yes, there's nothing else on the agenda. Jim, did you make the motion to adjourn, Jim?
Yes.
And Elisa seconded?
Sure.
Okay. 1, 2, 3, 4. So all those in favor say aye.
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 Okay. Okay, so we are adjourned. Thank you, everyone.